That's loud. How are y'all doing? I hope that woke you up. Welcome to day 4 of the Cardi B trial. We did a sprint over the weekend. I cannot believe that it got done. Your girl was live for 9 hours. Oh my God, 9 hours. 9. I could not believe that I still had energy at the end of that. It was insane. But for those that came out over the weekend and watched it, thank you. It really means a lot to me. And yes, court started late. They were supposed to start at 12 o'clock Eastern Standard Time, 9 o'clock Pacific, and they just started like 15 minutes ago. So Cardi's not even in the courtroom yet. But I heard that she just got there. So for those that missed the 9-hour stream, I have my editor who is fantastic. He is amazing at what he does. He is currently chopping that down to like 20 minutes. So you'll be able to catch up on the Cardi B case that quick. So hopefully we'll have that video done tonight. So if you're jumping in right now, you're coming in at a good spot. It looks like Imani's case is almost the plaintiff, not prosecution. The plaintiff is almost done with their case. I believe they have 3 more people left. Cardi B started on Friday with 3 people as well. So we have gone through 9 witnesses so far in a 9-hour stream. I just jammed it all in the day. Like it was crazy. So it's going to be interesting. That being said, I'm going to bring us to the courtroom, but real quick, I'm going to let you guys know first because it's a huge accomplishment. And that is also why the stream was late. AV to the 7th power. This girl is speaking at Vid Summit. Okay, Vid Summit, a speaker. I'm teaching a workshop. I'm going to teach other creators how to do this. Okay, so we're going to formally announce it. They are putting it on the website, I believe, right now. I will put it on the community tab, and then along with some other interesting things that we're doing with the channel, just to be a little bit more creator friendly, all of that great stuff. So huge accomplishment. I'm a little nervous, but also excited at the same time. As far as Thug, we are also working on a video on that one. And I'll also tell you guys as well, I got really motivated to see so many of you pop out on Saturday because some of y'all I haven't seen since YSL days. I was like, where is everybody? Like I was doing the Adelson case. People were not coming out, but y'all did. So I was like, man, this is my core audience, and even new people found us through that. Now, here's the thing. For those that had been with me through the Thug case, we covered it almost every day for like 120 days, right? We did take a little bit of a hiatus during the beginning, but we jumped in closer to when things were getting hot with Brian Steele, all this other stuff. Now, a lot has happened over the weekend. I was up pretty late on Sunday catching up on everything. But to answer your question, Ari, there are allegations of Young Thug telling, right? Now, the announcement is, I think I'm going to start doing like hip hop, true crime mini documentaries, right? So what I'm going to try to do is gather everything that I know about the YSL case, all of the stuff that has come out over the years, and start making true crime type of videos for y'all. Because I say that in my intro. I'm like, hey, we talk about all things law, true crime, and debauchery. Yes, we talk about debauchery, right? Like I'm an AG girl, right? Like that's the debauchery. The law is these court streams, these trial streams. But I noticed I haven't been giving y'all true crime in a long time. So we're going to start doing things like that. And I really want to start bringing a lot of energy back to this channel. So y'all, it's really I'm thankful for all of y'all. Like y'all came out on Saturday, been playing with these ideas, and we're gonna go into it like that. Also, you guys might have heard the news about Lil Woody. I sent him a DM. I hope he is doing better. I was, a lot of people were freaked out that something might have happened to him because of all the things that are happening in the news. So anyway, those are your channel announcements. Let's go to the courtroom and see what debauchery Miss Imani is going to bring us today with her struggle attorney. He is wearing the brown suit. The struggle is real. It has began. I'm going to go ahead and put the volume booster on before I press play. And let me know what y'all have in your cups. Your girl just got a fresh coffee, but let's jump on into it.
I wish they would have it that way. Change what I've already read.
Let me refresh this real quick, y'all.
So, but you do have a punitive damages question linked to.
I don't hear anything.
Oh, so you're going to keep the
Y'all hear anything? That's why
I did give these three instructions. I gave them as they're printed out.
There we go.
It's just without the. I think the proposed
Let's do it.
instructions had language that I struck out, so this is just a clean.
The one that I submitted this morning is directly out of KC.
But you combined 3903 and 3903A, and that's not how I gave it. So if it had been given to me that way originally, I would have read it that way, but I didn't. So I don't want to change what I've already read.
Okay.
All right, 3905A. I think I already gave a version of that as well, right? Oh, maybe I didn't.
I'm not sure. Your Honor, you asked that we just include the case instruction rather than a special instruction. So this is just the case instruction.
Okay, so I will do that.
Your Honor, I also submitted a 3905.
Is that straight from the casing?
Straight from the case.
Okay.
Are they
They're the same.
They're the same?
Correct. All right, 3934. That was not in the original package?
That wasn't the original package.
It was?
It was modified only because now that the damages are more limited than what Ms. Rosenthal was proposing earlier, we've just changed the last sentence.
Oh, okay. And I did not read that on Wednesday. Is that correct?
I don't believe it.
Correct.
Okay, so I'll give 3934. Special instruction number 8.
Special instruction number 8, there are just two differences from the Casey instruction. The first is that punitive damages cannot be awarded if there was accidental harm. The second is to include that's paragraph 3. Paragraph 4 is to include provocation as part of the jury's consideration of punitive damages. And we've identified a lot of supporting authorities in the notice that we filed with it. And I believe even Wittgen states that it's proper to instruct the jury on provocation when they're considering punitive damages.
Yes, Your Honor. My understanding was the trial would be bifurcated, and we would only get to this point after the jury made its decision as to the first non-punitive damages stage.
Well, this is a modification of the Casey that is given during the first phase. So do you want to be heard on the modification, specifically accidental or heat of passion?
Again, Your Honor, I don't really see a need for this one because there is a specific Casey on punitive damages that can be read.
I understand that. He is suggesting that it'd be appropriate to amend the Casey to add accidental harm and heat of passion. Do you want to be heard on that?
Yes, Your Honor. So my point is that none of the cases should be changed. And this is an example of one that's really so far off and completely different than what the Casey states. So that's my position.
All right, submitted.
Yes.
All right, I think special instruction number 8 is appropriate, so I'll do that. Special instruction number 9 is going to apply until we get to punitives. All right, let's go through plaintiff's proposed instructions.
Your Honor, there's one more I need to add. 3932 life expectancy. I have it here.
Is it printed out?
Yes.
And it's the math right?
may not be. I'm willing to reduce it if that's the case, but I believe it's close to the number. Oftentimes, we'll have a stipulation with council, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So what evidence do you have that she will continue to have future? I guess she testified that it still bothers her, is that?
Yes.
Okay. Any objection to 3932?
Yes, Your Honor, I'm not sure that she testified that it's a bothers her, but in any event, first of all, this was never shown to me. We're not sure that the math is correct. And this is just not an appropriate, instruction in a case like this where it's over an alleged scratch and there's a overwhelming amount of evidence that it wasn't caused by it.
Ooh.
You want to respond to me?
Uh-oh.
So I'm pretty confident that if it was changed to 40 years, it would fall well below the threshold of the National Violent Statistics Report. So I'm willing to do that. If there's a different number that they propose, I'm fine, but there should be some kind of KC 3932 of life expectancy so that the jury can understand that.
Where's that chart in the cases? Oh, here it is. Is she 32 today?
Yes, she's 32 years old. Yes, she is.
It appears to be correct. This is 50.3, and they've got 15. All right, I'll go 3932 over plaintiff or defendant's objection.
Thank you.
All right, plaintiff proposed 3901. I think I already gave 3901. Is that not correct? No, I gave 3900. I did. Oh.
Your Honor,
Yeah. So 3901 is only if liability's been established, not contested.
I apologize. That's an error.
Okay, so that's withdrawn?
Withdrawn.
Okay. 3902 already gave. 3903.
So this is all preliminary stuff for those that are wondering what's happening. They have not started the procedure or proceedings for the day yet. They're just talking about housekeeping stuff. So on Friday, we went, not Friday, Wednesday, which was day 3 of this case, we last left off with the judge preparing for jury instructions. What are jury instructions? Jury instructions are typically put together when the jury's about to start deliberating. These are everything that the judge is telling them that they are supposed to be doing, everything that they need to know before they deliberate, what the law is for assault and battery in the state of California, and in order to find that Amani is owed this money by Cardi, he has to really outline what they're supposed to be looking for and all the testimony and the evidence that was presented to them in order to prove it, right? It's $24 million. Is this woman going to get the $24 million over one scratch? And I mean, in the video you'll see tonight, I talked about the discrepancy between the hand going like this because we have Imani on camera saying that Cardi B was in her face like this. Now, her doctor, her own doctor, said that the scratch was caused by the 3 fingers in the middle of a hand, right? That's how the scratch looked, like it, punctured the skin, so to speak. She did not take the pictures the day of the incident. No pictures at all. The only pictures that were presented in evidence was that picture that the plastic surgeon took before he did her procedure. That's it. I didn't see no scar. I didn't see the scratch. Did you guys see it? Let me know if you saw it because we're looking for it. It's almost like how we were looking for a Rico. This time we're looking for a scratch. I didn't see the
I
scratch.
did not give, but I think that was proposed by the defense?
That's correct, Your Honor.
And the defense version was straight from the casing?
Yes,
Well,
it's in the binder.
the one that I did, Your Honor, is from the case, which seems to have a lot more words than theirs.
Yeah, I already did give 3903.
So we're gonna go with their version now?
It's straight from the casing. 3905, I think I already did.
Yeah, you heard on that, Your
Go
Honor?
ahead.
So the one that I've submitted today has all of the different types of physical pain, mental suffering, and emotional distress. Their version doesn't really cover everything at all. It just has a small amount. It's missing an entire paragraph, at least a portion of it. So I would request that plaintiff's version be read.
Right, I just looked, I did not give 3905 on Wednesday. And plaintiff's is straight from the casing,
Yes, sir.
and defendant had a different one?
I think theirs is 3905A, so maybe that's why. I would like 3905.
Your Honor, I believe the difference is that 3905 and 3905A, we just submitted them as separate instructions, and plaintiff's counsel has combined them.
Your Honor, I don't think I've combined them, but
Oh, I see. The defense proposed version does not define,
doesn't cover it.
yeah, it's not the full instruction, so I'll give plaintiff's proposed instruction.
Thank you.
All right, 1600. I think I gave 1600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s, but I made a mistake.
Your Honor, it was the 1602 instruction, which was the special instruction 4 we discussed today.
I did give 1600 already.
I withdraw the objection as to the 1600s.
Okay. Did we give a version of that?
1602 is the special instruction 4 that we discussed a few minutes ago.
And that, okay,
And
so I'll give the modified version.
thank you.
1603, did we give that?
1603 was included in ours as well. I believe the court asked that we include it, so
Okay.
that's in our binder.
And 1604,
I believe was given.
was already given. All right, tell me we have an agreed upon word form.
Unfortunately, we do not, Your Honor.
And do you have any differences?
Well, yes, Your Honor. So I've never seen it the way that they proposed it, with the preponderance of the evidence language. It's also something that is just created as a form that doesn't really reflect any type of special verdict that's really I've seen in any case before. I'm not sure what that is. So the one that I've done, Your Honor, I've done two different ones. The distinctions of the two that I've submitted is page 7 is added, with respect to punitive damages. And the other version does not.
Hello.
The punitive damages.
That was so funny.
Question number 19. That is the only distinction between the two versions that I've filed with the court. And I did give a courtesy copy to counsel. It was filed today at 12:19 a.m. with two different verdict forms. I did give it without, I did submit it to the court this morning without the caption of the attorneys, just so it would be somewhat of a neutral form. And I request that one of these be used, because the one that we've provided doesn't really follow the usual method. It does, I don't think it even has a signature line. Let's see. No, I withdraw that, but it doesn't really cover it the way that's usually done from what I've seen. Thank you.
All right, so I noticed the plaintiff's version has damages for each cause of action, which is duplicative multiple times over. It also doesn't include self-defense, and it also doesn't include what was the other affirmative defense?
Contributory negligence.
Oh, comparative.
Yeah.
Contribute one way, one time.
Yeah. Thanks.
All right.
I can modify it.
Your Honor, if I may.
Yes.
What we submitted was to simplify the form as much as possible. I believe it even has fewer questions than the plaintiff's form. And that was after our discussion. The previous form was complicated, which we agreed. We believe this is clear cut. It includes all the issues. It should not be difficult for the jury to understand or to answer.
May I respond here?
Go ahead.
So the worst part of it is it again states by a preponderance of the evidence. That's not usually in the special verdict form. They put that throughout the questions, kind of limiting, kind of creating a way for the jury to think ahead of time. It just doesn't make sense to have that there. I can modify mine. I have a printer. I can make changes in a couple of minutes and print out the version the court wants me to print. And the special verdict that I've submitted, I've seen all kinds of attorneys use it. I've never seen this version. And they would have to change it anyway because of the preponderance of the evidence, and it doesn't really tell the jury how to move along. So, for example, under assault, you have a question, yes or no, and then it says if you answer the question 1 is yes, then answer question 2. If you answer no, then proceed to question 6. Theirs doesn't have any of that. It's very confusing and has that preponderance of the evidence language. So definitely I would ask that that language be taken out, preponderance of the evidence. And if it could follow more.
All right. For those that are just popping in, remember this case is coming to a close. Cardi B is on her way to the courtroom. I just skipped ahead a little bit. I see her sitting down. So what they're talking about is jury instructions. All right. So it's a few more minutes of this, but I do want us to see it all, and then we'll hear from Cardi B. Look at what's happening here. 2 Minute Approve popped in. It said y'all are getting memberships. Okay, here's some memberships. It is raining in the chat right now. Thank you so much. 2 Minute Approve. Miss M got a membership. Dizzy got a membership. Ron got a membership. Karina, Christina, Courtney, Lee, Maricela got one. Amazing Disgrace and Dusty Lane all received memberships from 2 Minute Approve. And guess what? I see you, 2 Minute Approve. I'm going to go ahead because every creator once a month gets memberships that they can gift to their community. YouTube gives us 10 to gift out to people. So I'm going to join you. There's AV giving out 5. Look at me. Shout out to me. Look at me giving out 5. Let me give you 5 more, right? And I do this every single month around the first of the month. So we just hit September 2nd. There you go. Y'all get 5 more. So Tyro got a membership from me, from yours truly. Long Handsome got one. Melissa got one. Wilkes got one. Karma got one. Gail, Chrissy, Aloncita, Truth Be Told, and Rita. There we go. Our memberships have been gifted. That's 20 of them in less than 2 minutes. That's 2 minutes approved. Okay. Enjoy work. 2 minute approved. Thank you so much for popping in. And, you know, as a creator, I love to give back to my community. You guys are like my faves. I love y'all. Let's get back into these jury instructions and see what the day holds with Miss Cardi.
All more along the lines of a special verdict form that would possibly make it a better form, but still, we'll confuse it.
Your Honor, as far as the instructions, it's just clearly not true. The verdict form specifically states what the jury's supposed to do after they answer every question. There are other problems with plaintiff's form that would be beyond just little modifications. As you mentioned, the damages issue is very likely to lead to confusion and possibly duplicative damages awards. So if the court is inclined to ask that one of these be modified, we believe it should be this one. And we would, if the court has an issue with abundance of evidence language, we can strike that language. Otherwise, it would be the same.
Can you strike it and print it?
Yes.
In the next 5 minutes?
Certainly in the next 10 minutes.
Be heard.
Go ahead.
So again, Your Honor, the way that they've had it is not the way that the Casey instructions read. The Casey instructions do not have these boxes. It's a confusing way. It doesn't allow the jury to really answer the questions. They have to just say yes or no for everything. It doesn't break it down. So, for example, they're not able to answer the 4 parts of the question. For example, assault, it has 4 parts, and their form does not have the ability. The jury cannot answer the 4 different parts. They have to either go with everything or nothing. And that's not how a special verdict form or any verdict form is done. So I have a printer with me today. I can make changes. I can email it to the court if the court wants to do something with it. Their form doesn't cover any
Oh my God, he is such a budget attorney. That's why he's wearing the brown suit. So he just said that he bought a printer with him. Have you ever? I've never heard that before. I've just never. I can't with this guy.
these questions for any of them. Either it's all or nothing. And that's not how a special verdict form reads. So I would ask that the court. Well,
I'm just inclined to do a general verdict at this point in time.
I'm willing to accept that, if that's what the court wishes to do, but theirs is really off base, and it does not cover all the 4 parts.
Your Honor, there's multiple causes of action, affirmative defenses that apply to some causes of action but not others. We believe it's important, at least for our appeal rights, among other things, that we have a special verdict form in this case. I'd be happy to work on it.
Well, I mean, actually, I think the defendant's proposed verdict form is the equivalent of a general verdict.
Well, may I be heard, please?
Go ahead.
So again, I'm looking at my form here, and first of all, the question is, are we doing the punitive damages question? At least I can narrow it down to, does the court want number 19 or not?
Well, I'm not inclined to do the plaintiff's version at this point in time.
No, I understand, but I just want to know if you want to have punitive damages, if that question, because the question is the same.
Your Honor, under the motion to bifurcate, the jury decides entitlement to punitive damages.
Exactly. So here's my question on punitive damages in the defense's proposed version, you've got punitive damages attached to negligence. Was that your intention?
Along with the instruction that it cannot be caused, that punitive damages are not awardable if the conduct was by mistake.
I'm sorry, you saying you can get punitive damages for negligence?
No, not if it's by mistake.
Not if it's what?
No, we don't believe you can.
Okay, so but you do have a punitive damages question linked to question number 9, which is damages for negligence and comparative.
We can strike out the end of that of 12.
Okay.
Question 12.
Here's what I want to do. I think the defense version of the verdict form is, for all intents and purposes, a general verdict on each cause of action. I think it's straightforward. I don't think it's confusing. And so the only remaining issue that I have with it is that you've got damages for each section, whereas there's a jury verdict that says that they only decide damages once. So how do we deal with that?
So we did it. We did the form this way just to avoid having to ask questions like, did you answer question this? Did you answer question that? However, if you look at question 7, for example, it says if you already answered question 4, which is the same, skip this question. So the intent is to have only one of those be answered. And if you fill the form out, that's how it works.
May I respond now?
Go ahead.
Each cause of action can have its own separate damages. And that's why in their form it is the way that they have it, and that's why I did the same thing. So I would request that the jury be allowed to break it down on damages and decide what type of damages are for assault and battery. Those are kind of coupled together. It shouldn't be, but they are. And then intentional infliction of emotional distress.
Oh, come on.
And then
I want to hear these jury instructions. So intentional infliction of emotional distress is a tort, right? That's like in personal injury law, right? She is suing for the damages, like all the medical balances, right? But then the other thing is intentional infliction of emotional distress. That's the PTSD. When I was in law school, I couldn't believe that was a real, like a harm against another person. But that is the PTSD, the insomnia, the anxiety, the things she suffered from after this incident with Cardi B. So, I mean, I can't.
arguably kind of makes sense to me. Let's say that they find that the assault was limited to the scratch and nothing more. That the scratch itself did not cause past or future, maybe isn't going to cause future emotional distress, but they find that the intentional infliction of emotional distress was more longer lasting.
For example, Your Honor, have you heard?
Go ahead.
For example, they may find that there was an assault and battery and no intentional infliction of emotional distress. By removing the damages section, they would never be able to award any damages. So that's why I request that it at least be left there so that they could give damages to the parts that they wish to give. And counsel on both sides can argue duplication, don't give it twice, break it down.
Your Honor, that would be incredibly complicated, difficult to separate. It wouldn't work. I understand your position, but there needs to be some way of ensuring that there's not duplicative damages awarded.
Your Honor, they have multiple attorneys on their end. They created this form. If the court is going to go along with their form, then they should have to live with the form they created.
The form that we've created does not have that risk of duplicative damages. The other thing is that I think we've already established with the jury instructions that there are not damages that are awardable under some causes of action that are.
May I add one more thing, Your Honor?
Go ahead.
Yeah, I'm sure the court has seen it in many cases where it is broken down. There's the damages award specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction of emotional distress. In closing argument, counsel obviously can argue how this form should be filled out. And as confusing it is to me, I'll have to just live with it. To take away the damages section in assault and battery would mean that it's too confusing. It should be separate so that the jury can decide whether there should be any damages for assault and battery and any damages for any other cause of action.
Your Honor, we could, in theory, have one question for the damages and just not duplicate them. And that the only difference there would be we would have questions like, did you answer yes to question 3? Did you answer yes? Like what we did with the punitive damages. That would be one of the differences.
How about we modify question 7? What are Ms. Ellis's damages? If you answer question 4, only include additional damages for this cause of action.
Can we include if any, Your Honor?
If you.
I'm confused. So again, it is very confusing because assault and battery is a separate cause of action and it has its own damages component. By leaving the form as is, the jury can then decide if they're going to get any damages for assault and battery.
They can't. It's under question 4.
Right, in 4. And then they can do it again for 7. They can do it again for 9. They might not do it in any of them. So that way they're able to break it down and decide what, if any, damages they're going to be awarded. Each cause of action has its own damages award.
But you can't double count.
I'm sorry, Aaron?
You can't double count though.
Double count, what does that mean, Aaron?
Meaning include the same emotional distress that if they find that she has a certain amount of emotional distress, are you asking them to allocate it between the different causes of action or just?
No. I'm just straight asking assault and battery. This is what it is. If you find that an assault and battery, it should really be separate. Now, let's say we take it as together. We say, was there an assault and battery? And then what are the damages for assault and battery? It's really harmful to have it assault and battery combined because the swing that was taken was the assault and the cut to the face was the battery. So we're then limited to one damages in number 4. We're limited to one set of damages for both assault and battery. So then in my closing, I have to explain that. Same thing, intentional infliction of emotional distress. Separate cause of action, it has its own damages. Negligence has its own damages.
Your Honor, I believe that, first of all, the addition that you proposed would address that. Not including something or just including more damages questions would make everything more complicated. Another proposal, Your Honor, however, is we could do separate verdict forms, one for and have damages only after liability. It would make things less complicated.
Go ahead.
So yeah, separate verdict form complicates it even further. This is a form that defense has prepared. It was well thought out, and it doesn't even break down the 4 different parts of the question. If we're going to live with this, I ask that at least we have those damages for each section. I'm not going to ask for the same thing 3 times. It's going to be broke. If I'm going to do it, I'll break it down. this is worth this, the other is worth the other. It's not the same, Your Honor. So I asked that the form we submit it as is, and we just, if the court is gonna go along with their form, then at least I would ask that. Thank you.
All right, I'm gonna ask that you modify question number 7 to, if you answer question 4, only include additional damages under this cause of action, if any.
All right, that makes sense. Thank you. And what happens with the other one, Your Honor, number 9, same thing?
Same thing. Can we do that?
Yes, Your Honor, thank you.
All right.
And Your Honor, will we be giving number 13?
Yes.
Your Honor, just to confirm, question 12, we're going to omit the last 3 words for question 9.
Correct.
Thank you.
All right. There's a request for judicial notice regarding the date of the NBA game.
Yes, there is. I did file that this, yesterday, and I served it a copy on defense counsel.
And I'm sorry, what was the testimony of the date that the photograph was taken?
Miss Almanzar stated that that the photo was taken on the date of the NBA All-Star game, which was the date of the accident, the date of the incident of February 24, 2018, about 6:30 p.m. She testified that that's when the photograph was taken, and her nails looked like that on that date. There's no question that the All-Star game was on February 18th of 2018, so it's just clarification so that the jury is clear of when the game is. This is common knowledge. There's no question about it. I've given different exhibits confirming that the All-Star game was on February 18th of 2018, and that's why I found this.
All right. And for the defense?
Yes, Your Honor. What Mr. Rosen is saying is absolutely false. I'd like to read what my client testified to.
Why am I not
Cardi,
surprised?
put this in front of you. Cardi, can you please look at this photograph and tell me, do you recognize this? Answer, yes. Question, what's this photograph? Answer, that is me out here in LA at the All-Star Weekend NBA game. Question, does this picture refresh your recollection about what your hair color was that week? Answer, yes. What color was it? Answer, I'll say
Read
like,
more slowly, please.
sure. Answer, I'll say like an ashy, dirty blonde. Question, can you see your nails in that photo? Answer, yes. Question, were you wearing acrylic nails or some other type? Answer, acrylic. Question, I think you testified yesterday that acrylic nails can last you up to 2 weeks. Is that right? Answer, yes. Question, are those the nails you had the entire time you were in LA? Answer, yes. And I can continue reading, Your Honor, but nowhere does my client say that this was taken on February 24, 2018. She doesn't reference a date. And Mr. Rosen represented this to you twice last Wednesday, that the court was advised and everybody was advised that it was on February 24th of 2018. He later said she testified that she got this picture taken on the same day. She testified under oath that at 6 p.m., he just said 6:30, on February 24th, 2018, that this picture was taken. That's absolutely false, Your Honor. I'd be happy to provide a copy of the transcript to the court.
Okay.
May I respond?
And one other thing, Your Honor, may I-
Go ahead.
my understanding under California law is that you can't take judicial notice of the truth of the contents of a website. And there is case law on point I can refer the court to.
Well, I'm not necessarily worried about that. I'm just worried about whether, I don't think that there was any representations of the date it was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material.
May I respond?
Go ahead.
So, the purpose of this is really not to make anybody right or wrong. The purpose of judicial notice is just to clarify the All-Star game took place, and the second half of it is when the photograph was taken. There's overwhelming evidence attached from different news outlets. There's
Again, is it material, the date? She said she had those nails for the entire week.
It's material, Your Honor, because the defendant testified that that's what she was wearing later in the day, the exact same day. She had those nails. You have on the same date of the All-Star game and the same date of the incident.
There's Cardi.
What was the
Here
error
come Cardi.
is that the All-Star game was on February 18th of 2018, and the court said that we didn't have credible evidence at that time about it, so that's why the judicial notice was prepared so that the court can see for itself that the All-Star game was on February 18th of 2018.
Okay, I'm gonna deny the traditional. All right, are we otherwise ready?
There's one more thing though.
Go ahead.
The court asked that I prepare a statement regarding the death of John Sherritt.
Okay. You have that?
Yes, I do. I did give it to the court. It would say plaintiff testified that she treated with John Sherritt MD in relation to this case in 2018. It is undisputed that Dr. Sherritt died on March 5th, 2021.
After a lot of back and forth, what we agreed to, what I agreed to, was that the court can instruct the jury that it is undisputed that Dr. Sherritt died, period. This March 5th, 2021 date, it's not in evidence. Plaintiff didn't testify. She said she understood he died sometime in 2021. She also testified, and we launched the transcripts. I can cite to one of the transcripts. She says it. Page 148, lines 12 through 149, line 15. She says that she went to see a Dr. Sherritt, and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Sherritt is not supported by the evidence. The only portion of this that is actually what I agreed to was it is undisputed that Dr. Sherritt died, period.
Okay, you heard. So, this is what I would propose reading. Plaintiff testified that she treated with John Sherritt MD. Does not dispute that Dr. Sherritt passed away.
Your Honor, she did not testify she treated with Dr. Sherritt. She sought medical treatment. This is page 148, line 12 through 14. Around that time, I don't care when that is, did you also seek medical treatment from Dr. John Sherritt? I did. And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So,
Okay.
that goes on page 149.
So I will read. Plaintiff sought treatment with John Sherritt. It does not dispute that he's passed away.
Well, plaintiff testified. Plaintiff testified she sought.
Very good.
Thank you, Your Honor.
What will it read, Your Honor?
Plaintiff testified that she sought treatment with John Sherritt MD. It does not dispute that he has passed away.
Thank you, Your Honor.
Now we're ready?
Well, there's a couple things. In my closing argument, I need the verdict form. So I can't start without
We're working on that.
that in hand. The other thing I wanted to say, Your Honor, is Your Honor did allow me to argue and clarify the NBA All-Star game when it was, the photograph. I want to be very clear that I intend to argue that in my closing.
It's not in evidence. I think what you said was they didn't provide the date. And you're fine. You can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing,
You could argue it. You could argue that they didn't establish what the date was.
and also that the All-Star game was on February 18, 2018, the week before. But the week before the incident, I don't see the harm in that. They can object to that. They can say their version. But that's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It was never produced in discovery.
Go ahead.
Just briefly, a couple of questions. First, if you remember, counsel violated a motion in limiting order and now he's talking about arguing things that are not in evidence, which is completely improper. I don't want to object every 5 minutes to his closing argument. I would ask that
Uh-oh.
at least let me say, if the court doesn't want to tell him, that he has to follow the rules.
He
can't
does.
talk about, things that aren't in evidence. He can't violate the motions to eliminate.
I think it's readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside.
Oh, the judge is like, because this is Cardi's attorney. He's just like, you know what? As we're getting ready for jury instructions, we're getting ready for closing arguments, we're finalizing all of this, right? We're going to put this case in front of the jury for the final time. It needs to be clean. And judge, if you don't want to tell him that he can't violate the rules, I'm going to tell him he can't violate the rules. And the judge is just like, well, I think this $2 attorney in the brown suit that blends in with the rest of the courtroom, he knows that if he does break those rules, he will be, bending the rules and looking at an ethical violation. What does that mean? It means that he can be reported to the bar, right? The California Bar Association. And that's not a good look. That is not a good look. Do you know how embarrassing that would be to lose this case, lose the $24 million, have this, be the only attorney that did not exceed, or sorry, one of the only attorneys that did not succeed in suing Cardi B, because he'd be joining Olga. Y'all remember Olga, right? And it's just a bad look. Like, that would destroy this guy's career.
The evidence that was presented in court. If he wants to present that and you want to object, then that's how we'll proceed.
Thank you, Your Honor.
Are you the same? Are you done?
Then two procedural questions. Does the second monitor work and can it be facing the jury so they can clearly see it?
I don't think so. We're in the middle of a transition and I don't know.
Okay, and
We can see it's not.
Your Honor's preference, we have demonstratives and we have things we're going to show or intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay, I just want to make sure. Thank you, Your Honor.
All right, anything else from plaintiff's counsel?
Yes, Your Honor. I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence.
I think you just said you were going to.
No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the day.
Correct. Your position on Wednesday was that they didn't establish the right date, and you can make that argument.
That's exactly what I wanted to do.
Okay.
Thank you very much, Your Honor.
All right, are we ready to move to the jury?
I must have the verdict form before I start.
All right.
They're being printed right now.
All right. Let's move in.
All right, the jury is finally coming in. It took them forever to start. Wow. At this point, it would be what, 11 a.m. over there in Cali? Is that what time it is for my West Coast people? 11 a.m. That took forever for this day to start. They should have gotten started at 9, but wow. So what can we expect today? Today should be the last day of this case. I think the $2 attorney might have 3 more witnesses. If not, then we are going to proceed to jury instructions and the jury is going to go and deliberate, right? So what do y'all think the verdict's going to be? Is it going to be, it's not even guilty or not guilty. Is Cardi B going to have to pay this woman for a scratch? Yes or no? Let me know what y'all predictions are in the chat.
All right, welcome back, everyone. We're still on the record in the Alice matter. We now have defendant with us as well as the members of our jury and our alternate. Based on the fact that you're all here, I'm assuming no one hit the lotto over the weekend. Folks, we thank you for your patience. We did have a few procedural issues that we needed to address prior to bringing you in. We are now ready to proceed with the last batch of jury instructions. I'll try to give context to these to the extent that it's necessary. I will put them into the package where they belong, but I do need to give these to you. And we're going to relieve the court reporter of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almanzar assaulted or battered Ms. Ellis, you should fine for Ms. Almanzar if you decide that Ms. Almanzar was acting in self-defense. To succeed, Ms. Almanzar must prove both of the following by a preponderance of evidence: that Ms. Almanzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almanzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almanzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almanzar must prove both of the following: that Ms. Ellis was negligent and that Ms. Ellis's negligence was a substantial factor in causing Ms. Ellis's harm. If Ms. Almanzar proves the above, Ms. Ellis's damages are reduced by your determination of the percentage of Ms. Ellis's responsibility. I will calculate the actual reduction. Ms. Ellis may only establish her claim for negligence if she proves that Ms. Almanzar engaged in negligent conduct that caused Ms. Ellis to suffer physical injuries. If Ms. Ellis can prove that Ms. Almanzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Ms. Ellis cannot establish her claim for negligence. Emotional distress in suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Ms. Ellis claims that Ms. Almanzar assaulted her. To establish this claim, Ms. Ellis must prove all of the following: that Ms. Almanzar acted with the intent to cause harmful or offensive contact, that Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner, that Ms. Ellis did not consent to the conduct, that Ms. Ellis was harmed, and that Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds of decency. Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether defendant abused a position of authority or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was particularly vulnerable to emotional distress, and whether Ms. Almanzar knew that her conduct would likely result in harm due to mental distress. Under factor A, which is the position of authority, examples of positions of authority or relationships of power include an employer, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almanzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almanzar knew that emotional distress would probably result from her conduct, or Ms. Almanzar gave little or no thought to the probable effects of her conduct. If you decide that Amani Ellis suffered damages that will continue for the rest of her life, you must determine how long she will probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another person is likely to live, but is not conclusive, probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another person is likely to live, but is not conclusive. In damages from Ms. Almanzar under more than one legal theory, however, each item of damage be asked to decide whether Ms. Almanzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by Amani Ellis. Physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional distress, Amani Ellis must prove that they are reasonably certain to suffer that harm. For future physical pain, actually, I think, okay, no, we're fine. For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate Amani Ellis for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almanzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almanzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almanzar engaged in that conduct with malice, oppression, or fraud. If you define that defendant accidentally harmed plaintiff, punitive damages are not appropriate and should not be awarded. In deciding whether or not to award punitive damages against the defendant, you may consider whether defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with the intent to cause injury, or that a defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences. Oppression means that a defendant's conduct was despicable and subjected the plaintiff to cruel and unjust hardship in knowing disregard of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed the material.
For anybody coming in, we are reading jury instructions to the jury members. We're still going to hear the closing arguments. But before we do, just want to shout out Nature Self-Study. Thank you so much, Nature, who is dropping 10 memberships in the chat today. We're up to 30 gifted memberships. 10 came from me, 10 came from 2 Minute Approved, and 10 are now being distributed from Nature Self-Study. If you received a membership, please say thank you to Nature Self-Study. Super, super nice. And it's good to see you, Nature Self-Study. It's been a little bit. Good Girl got one. Valinda got one. Ravens Girl got one. Dr. Reese got one. TC Brown got one. Faye got one. Chatbox got one. Cheeto Bay. All types of folks. Thank you so much. Detect Vids got one. Astro Box Bear received one as well. And Nature Self-Study, thank you for dropping a $50 super chat. Thank you, guys. Nature Self-Study is now your stream sponsor. Thank you, thank you. Really appreciate all the love and the support. Nature Self-Study says, still here supporting. School's been busy, but making it through your live. Thank you, AV. That's right. And anybody that's catching up, we do have a full video of all of the witnesses coming out tonight. We're just putting the finishing touches on it. But thank you so much, Nature Self-Study. Good luck with your studies. We're all cheering you on and really happy that you caught a live today. And it's a good one because it's going to be the closing arguments. I want to see what the $2 attorney is going to say. Y'all tune in. Let's jump right back on in.
Fact, and did so intending to harm the plaintiff. During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away. All right, ladies and gentlemen, that concludes the additional jury instruction, and we're back on the record with the court reporter. That concludes the additional jury instructions that we are adding to those instructions that I previously read. At this point in time, it is the time for the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who are to determine the facts, and to the extent that the attorneys argue facts that you do not believe were proven during the trial, please rely on your own finding of what the facts are. And similarly, to the extent that the attorneys argue law that is contrary to the law that I've just given you, please rely on the law that I gave you. And with that, is plaintiff prepared to give your closing argument?
Yes, sir. I'll just ask for a quick sidebar for a moment, please.
All right, they're doing a sidebar. And as they are doing that, I have a poll up for you guys to see how long we think it's going to take the jury to deliberate. 64% of you say less than 4 hours. 24% of you say end of day. 11% of you say tomorrow. Yeah, I mean, here's my prediction. The jury was very attentive during this case. You don't see it in every jurisdiction in every state. I break that down in our video that's coming out tonight. They were asking a lot of questions. And those questions came after almost every witness.
Sidebar, and now is plaintiff prepared to proceed with your closing argument as soon as you get there?
Yes, Your Honor. Thank you very much.
All right, here we go. Come on, $2 lawyer. What you got?
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
Here we go. Let's see what he says in his closing.
Thank you all for coming back today.
So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar or the cut came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails, and that there were 3 different scrapes, 3 different scratches, and that the middle one was the deepest one, and that's really the one that he worked on. Now, the issue in this case, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it.
Oh no, he did not say that to the jury. It doesn't show up well. Oh, we're off to a bad start. Oh my God, you want 12 million per each centimeter. What?
Deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us It's a disrespect to the judge.
Yo,
It's
look at-
disrespect to this courthouse. You cannot come to court.
You see Cardi's face? Oh, this closing's about to be good. Let me go back. I know he did not cry about
And
that.
disrespect, B word, all these different words. It's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot
She's like, Ninja, what? What are you talking about?
come to court and say these kind of words. It's just disrespectful. And just because Miss also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people.
Wow.
If you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were
Trauma.
doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that.
Look at Stephen Colbert behind Cardi. Like, Cardi's team is laughing at how bad this closing is. Cardi's shocked. She's like, what are you talking about? This is the funniest closing I've ever seen. Like, you can't be serious. He's like, yeah, maybe he's a nice guy. He's trying to switch words, twist words. What are you talking about? Oh, she had all this trauma. She could never be a security officer again. Boo-hoo. Oh my God, give me $24 million. Cardi B is swearing on the stand. Yeah, so did your client. So did your client. Is that not disrespectful? Did you not ask her verbatim what the quote was that she said? So, the struggle lawyering is real.
The plaintiff didn't suffer any emotional injury. That's not the facts. The facts are Imani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Imani Ellis suffered.
I respect everybody in the legal profession, but this is so bad. Look at Cardi's face. She said assaulted and battered. Like, what are you talking about? I didn't even touch her. What? Let's go back. Look at Cardi's face. She's like, you cannot be serious, dude.
And battered. I can only imagine the embarrassment, the emotions, the pain that Miss Imani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And
Security heavy.
there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building instead of listening to the plaintiff, to listening to her commands, you know, you got to do this, you got to do that, please leave the building. Different commands were given to her, which none were followed. They were all ignored. Instead, the defendant thought that, well, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person. And she simply, her whole goal of doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old, and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is recording video is not available while on the call. So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B, got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N-word to disrespect her, calling her the B-word, calling her fat, anything to try to trigger her.
He didn't
and make
say
her
that.
upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher a sentence that basically that there's this undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who's another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
Assisting.
Then we learned throughout the case that when Cardi B came to the building, she caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming to the point where 2 other witnesses, Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, was so loud that those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds before. So yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those two witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they
That is so stupid. So he's saying they didn't see it. They're not eyewitnesses. Cardi B sat on the stand. It was just like, there's not even camera footage. There's no camera footage. There's no eyewitnesses, and you're highlighting that and you're trying to win.
arrived, Miss Ellis was so upset. Can you imagine all those four things happening? Being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry, she was emotional. So when these two witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that. And they had assumed that it's her fault, maybe, or that she did something wrong. But again, those two witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the two people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? It could be from either one. It could be from the commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything.
You said you don't believe her. Why not? You should.
At some point during the trial, the defendant showed you Exhibit 232. You all remember this photograph? Exhibit 232. This is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection.
There is no proof of when this photograph was taken. It could have been taken at any time, before or after the incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor.
That was her testimony. But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the NBA All-Star game. There's no proof of that anywhere.
Yo.
That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on this photograph because there's no date on this photograph.
Oh, it just gets worse and worse and worse. It just gets worse. There's no date on this photograph. Oh my goodness. This is a celebrity can't prove it. Oh, this is terrible. This is the worst cross exam of all time. I just renamed the stream. Like, this is the worst one. Ain't no way. Are they going to convict, guys? Or not convict, sorry. I keep forgetting it's civil. They're going to give this lady her money.
The next thing that Miss Ellis did is she made an incident report. 2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, at least downstairs of the building. She had a security guard with her, Mr. Newton. Mr. Newton, that's her security guard. He didn't testify in this case. Why not? Where is he? Disappeared? Miss Ellis testified that when she saw this security guard downstairs in the lobby, she met with him there, Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified in this case, but he didn't. And there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So where is Mr. Newton? I don't know. He was on the witness list. He should have came here and testified.
Oh my God.
Another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case. And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw the Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. I'm sorry, if the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that In April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. Medical treatment was delayed. That's why Miss Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lien basis. Dr. Mulliken testified that he would agree that he treated her on a lien basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did. Dr. Mulliken testified that he fully examined Ms. Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Ms. Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Ms. Ellis could, there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind.
It does remind.
Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry. Oh.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor from the defense side. They could have spent money and hired somebody and had them testify here and tell us, yeah, Dr. Mulliken's work is no good, or she could have done something different, but we don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board-certified plastic surgeon for 30 years. He's affiliated with UCLA and even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves. Now, when you go back into the jury room, you will see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding.
Objection, Your Honor.
They were raised.
That's not what he said. This is awful.
When Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was a security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen. And that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony.
You know what? This should not be allowed. I feel Cardi. I feel Cardi on this one. How is this able to happen? How?
When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patrons and visitors. Cardi B refused to listen to the security guard who was working there.
She's falling asleep, bro.
At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor.
Miss Ellis's mother testified that she recalled.
And here's the other thing. Sorry to interrupt, guys, but I mean, you get what you get. Here's the other thing. It is very rare to get more than 2 objections in a closing argument. I've never seen this in my life. And you guys know we watch trials. I've never seen this ever in my life. How embarrassing.
The scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022. Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down.
Let's stick to what the evidence shows.
Yes, sir. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser, she didn't tell him about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If the third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case to, in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. Where we all know that when we go to a building, we got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything had already been done. The whole incident already happened. The injury was already complete. And really, this comes down to believing Miss Ellis. She gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her so that you could give her the peace of mind, the closure, and yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B. And Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again. Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Ms. Ellis also received another 12 visits. She testified that she saw psychologist Dr. Avila and other
Objection, Your Honor.
people in his office.
Violation of the court's order.
Move on. The other thing that Cardi B failed to do or could have done is she could have filed a cross complaint.
Objection, Your Honor.
All right. And then I want to go over a little bit about the medical bills. So you don't have to get it exact, doesn't have to be an exact number. But there was testimony in this case that Ms. Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Ms. Ellis could benefit from one more surgical procedure, another one, to make it better. The cost of that was $15,000.
Objection, Your Honor.
Oh,
The $15,000 that would be paid for that would, in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce, basically what I'm saying is there's still
Oh, make it stop.
some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around, you can look at it for yourself.
What?
There is still some scar on her face. It's still there and still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happen to Miss Ellis are they're wrong. And we want to make this wrong right. And how can we do that? For each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now for today's purposes is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, a component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering, you are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do. So when you go into the jury room, you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case. The first section A is the assault and battery. They are, in a sense, separate because the assault is the swing and the battery is the scratch and the cut to her face. However, it's very clear. Did plaintiff Imani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side. It's not broken down into four parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almanzar's conduct. Miss Ellis was harmed, and Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2, both of those. Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody and nobody touched me. So self-defense, no. You would say no. Then you can go, then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Miss Ellis incurred in this incident. So you will have in the jury room exhibit number 4. You'll have exhibit number 4, it's been marked at the bottom right corner. You'll have exhibit 4-1 through exhibit 4-6, and then it will skip over and you'll go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500. So past medical expenses would be $16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulliken stated that Miss Ellis would benefit from a future plastic surgery of $15,000. So you'd write $15,000 in that box. Pain and suffering. Again, there's past pain and suffering and future pain and suffering. The court read a time frame for you of how many more years Miss Ellis will live. And the jury instruction life expectancy, 3932, basically states that Miss Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she's going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period.
I can't believe this.
Again, you'll all have the jury instructions in the back when you go into the jury room, and the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important. So I would take a look at that one because it covers all of the different things. Embarrassment, pain and suffering, disfigurement, all of those. So if you look at 3905, it talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that. So for past non-economic loss, you should put a number there. Because if you don't, the award will be thrown out. You got to have at least $1 there. You got to award some kind of pain and suffering.
$2.
Required. Now the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury. Very serious. And Miss Ellis has been suffering for the last 7.5 years. What kind of weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to. So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic. We all went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized that your life is really about future non-economic loss. Again, that's going to be for the 50 years going forward. You could pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number 1, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. Miss Almanzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, again, it says, did Miss Almanzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is, if you feel there should be separate damages aside from the assault and battery for the emotional distress, then this is where you can give that amount of money. It'll be a separate and apart damage area for you to award more damages. Same breakdown. You can give past medical expenses, obviously, past and future medical expenses. In this, if you awarded in the first box, then you would say, 0 and 0, because we're not double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give $50,000 additional for the past, $50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove
Thank
all
God.
the following elements of negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar, was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through, the assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almanzar? Say 100%, and Miss Ellis, 0. And the final page deals with punitive damages. Did you answer question 4 or 7? And you look back, and if you did, which is the damages, then you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here. So at this point, I'm going to turn it over to my counterpart. They will obviously contradict everything I will say. I've told you, and then I will have a chance to come back and rebuttal and just clean up anything that was said.
No.
At this point, I'm basically Miss Ellis's mouthpiece, and work with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I had. And we really, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And we want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Imani Ellis went through. And I'm asking you to award Miss Ellis an amount of money that you think is fair, that will make her whole for the losses that she suffered in this case. Thank you very much.
One more time. Rick Ross laugh. What? You know what? I hope they just say no. Like no money across the board. 0, 0, 0, 0, 0, 0, 0. Flip the page. Just turn the page. 0, 0, 0, 0, 0, 0, 0, 0. That, ladies and gentlemen, was the worst closing argument in the history of mankind. It's terrible. Now we're going to turn it over to Cardi's team to see how they are going to rebut what he just said. And he says that he's going to come back up. I don't know where she found this lawyer, but she needs to get her money back. I mean, this is terrible. The thing is with ASAP Relly, at least ASAP Relly did the criminal trial first, and his civil trial is coming up in January. He's suing Taco Pina and ASAP Rocky again. He's going to lose that too. But at least he tried, right? Now, the thing is, a lot of you guys were asking, like, if Cardi can sue Imani, that would be a counterclaim. The issue is Imani don't got no bread. So what money is Cardi B going to get? You guys saw what Cardi B did with Tasha K. Tasha K filed for bankruptcy. But the difference is Tasha K has a business. She has a YouTube channel. She has an app. Like she's still a business person. Imani is just looking for a payday. So Cardi B realistically can't get her lick back. She can't. So what he just went through the entire form. You guys picked up on it. He went through all of their claims, right? Assault, right? So that's one of the claims. The next one, battery. All right, that's another one of the claims. Intentional infliction of emotional distress, another claim. Contributory negligence. Sometimes that gets included if the jury decides, well, it's not one person's fault per se. It's kind of both of their faults. But we have to see if the jury even wants to go up that path, you know. And then there's punitive damages, which are damages awarded to a plaintiff that are designed to punish the defendant. I don't think we're getting, I think it's going to be zeros across the board. What do y'all think? What do y'all think? Is it going to be $1 for this $2 attorney? I mean, and all this time, this is 4 days of a trial, 4 days away from her family, 4 days away from her businesses. It's crazy. So let's see what Cardi's team comes up with, because I do want to hear what they're going to say. Amani, I mean, wow. I could have, you could have found a better lawyer at Legal Aid. Like, I don't get it.
All right, thank you, counsel. You okay? You want to take a break? You okay? Okay, all right. Defense ready to proceed?
We are, but I would think a break would be appropriate at this point.
Does anyone want a break? We got started late. Okay, why don't we take a short break? Why don't we resume back at 11:25? In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you.
Oh my God, chat.
10:25. Or sorry, 11:25.
All right, luckily for us, we have an abundance of TIFO time, so I can skip us ahead of the break. And then it looks like Cardi's lawyers are up there now. We're not that far behind the mainstream. Let me just see if he says anything to them before the jury, after the jury leaves the room. Because that lawyer, I mean, Amani's attorney was also lying about a lot of stuff. Y'all were here with me on Saturday. We watched the whole trial.
The modifier we, it's probably, I wasn't going to get into it. It's generally not proper to include yourself in terms of what we all went through, but that's why I was overruling the objections. One note, and is this grandmother here?
Yes.
Ma'am, can I have you step forward? Can I have you step forward?
Oh, what happened with Granny? What's this?
And ma'am, you were previously sworn. You understand you're still under oath?
Sure.
Did you have any conversations with alternate number 1 on Wednesday?
Alternate number 1.
The woman on the corner? the woman who's on the jury.
No.
You don't recall any interaction with her?
She sat next to me and she was waiting on a break, but we didn't speak.
You didn't speak with her? Okay. So you didn't talk to her about the trial at all?
Absolutely not.
Okay. All right. You were just seeing, we thought that there may have been some discussion between the two of you. You don't recall that? Okay. All right. Thank you. All right. Well, something else?
Yes, Your Honor. Although you cautioned counsel that he can't argue things that are not in the evidence, he repeatedly did.
Take
He
his
even
bar
started
license.
talking about Dr. Avila's treatment, even though he was excluded. Over and over and over again, and all the jury sees is me objecting and Your Honor sustaining it. I would request that you admonish the jury to disregard all of the statements that you sustained objections to. I would also ask that you assign misconduct to counsel and that he be reprimanded because this has just been ongoing.
Okay. We can discuss.
I want to respond.
Well, let me do this. I will give further instruction to the jury about that the argument of counsel is not evidence and that they should disregard any comments that were not supported by the evidence. I will give that instruction. We can discuss whether or not we want to set an OSC after the trial for
Uh-oh.
Thank you.
Oh, Chad. Guess what Cardi's lawyers just did? So before, y'all all watched it with me, the beginning of this stream, we watched them come up with jury instructions. And Cardi's lawyer stood up and said, hey, he can't talk about specific things that never happened or that are not in evidence. That would be an ethical violation. And he could be reported to the bar, right? He still did it. He ignored the judge's rule, and Cardi's lawyers just stood up and said he needs to be sanctioned. He needs to be punished for ignoring that rule. And the judge said, okay, I'm going to give the jury instruction. I'm going to clean it up with the jury and say, hey, please disregard what he said about this particular thing. But then we'll talk about scheduling a hearing for the ethical violation. It just got real. So ethical violations could be, okay, you report somebody to the bar, right? Because when you become an attorney, there's two things that need to happen. One, you have to pass the bar exam, and there's a second exam called the MPRE, right? Most lawyers will take their MPRE and pass it before they go to their bar exam, take their bar exam after they graduate law school. There is a whole class in law school curriculum called ethics. And there are these rules, it's called the model rules of professional responsibility that lawyers have to abide by, right? That means things like confidentiality, like it's basically the rule book for lawyers. Here's what you can do, here's what you can't do. He had an ethical violation, so that means he broke one of those rules, right? What are the consequences for breaking those rules? Well, first, you get reported to the board of bar overseers for your state. That's what Cardi B's attorney just said. So he's just like, hey, he's not following the rules of the tribunal, candor to the tribunal, things of the like. I don't know what the exact rule was. I didn't hear it, but they're going to highlight it, right? So that's not good, right? Ethical violations are a stain on your record as a lawyer, right? So you have that piece. Now, it could be sanctions. It could be, hey, you can't practice law for 60 days or 90 days. It could be a few different options as far as what's happening. But you guys are watching history right now. I'm not kidding. I saw it happening in the first 10 minutes when he started talking. I was just like, you know what? This is the worst closing argument of all time. Okay, worst. It's bad. So now let's see what Cardi's lawyer says. And for those that are coming in after Cardi's lawyer finishes, the jury's going to go in the jury room and deliberate. Could we get a verdict today? Possibly. If not, I have some good news. My team has just finished. You guys saw me go live on Saturday. I watched the whole trial. We have condensed it down to a 20-minute video. So if they go and deliberate, what we'll do, I'm going to drop that video. So if you want to see it witness by witness by witness and see my legal analysis on how they did, you'll be able to do that too. But I know we have some super chats to read. I will read those towards the end. Thank you to everybody that's supporting the stream. All the ways you could support the channel and the stream and my team for bringing this great content is right here in the banner. That being said, let's go to Cardi's lawyers and see how they close up this case.
Yeah.
Please.
Go ahead.
I just want to note that you advised Mr. Rosen that if he were to argue to the jury that Cardi said that photograph was taken on February 24th, that would be a knowing violation of the professional rules, and that's exactly what he did.
Okay, well, why don't we, I don't want to do it now.
Well, I have to say something about it.
You don't. I said we'll discuss whether or not we want to set an OSC and we can address it then. Okay?
Thank you, Your Honor.
All right.
All right, so they took their break. Let me skip ahead and bring us back to Cardi's lawyers right around here.
And evidence during.
And, oh yeah, the judge is going to give that curative instruction before.
When you left the courtroom, Mr. Peterson made some remarks to me that were rude.
You know, why don't we do this later? I'm not going to have to wait for
I
that.
ignored him. I didn't talk to him.
Okay, all right, we're going to bring in the jury.
It's complete falsehood.
It's Mr. Anderson too.
This is bad, Chad. This is so bad. It's embarrassing.
Our
Okay.
jury and our alternate. And before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections. To the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial, please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial. Okay? All right. With that, defense can you give their closing?
Thank you, Your Honor.
Thank you to Miss Zoe, your stream sponsor. Y'all type Zoe in the chat. Zoe is sponsoring this train wreck.
I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that, it's just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statements, I told you what I expected the evidence to be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show, and that I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in. Witnesses have testified that exhibits have been admitted. And if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated on this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%, she starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has. That arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they cause someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation, who caused the incident. And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way, I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true. Okay? She has her version, but the fact that she alone says it does not actually make it true. And this later this morning, maybe stretch into afternoon, I'll tell you or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. The plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor.
And she actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on this scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-bill, cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls and she makes calls from 11:20 a.m. all the way to 3:35 p.m. and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021, she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021 is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulligan. She went to plastic surgery 4 years later after being in a car accident.
Objection on this case.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today, that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower. I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of
I didn't want to interrupt him by cooking while he's cooking, because he really is. He's doing a wonderful job. Just a brief reminder, if y'all could do me a favor, hit the like button, get this out to our normal people so more people could see what great lawyering looks like compared to struggle lawyering. Do me a favor, hit that like button. Thanks again.
this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Actually, we're not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. You know, we all have relatives and we hope our parents believe us and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay. We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything. And they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi, half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay. Well, that sure doesn't square with the testimony of Tiara Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek? But in plaintiff's own incident report, she said she told her supervisor, Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Imani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday, question, you didn't call your grandmother though, did you? Answer, no. Okay. So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses is Dr. Mulligan. Okay, that's what she offered to support her claim. Of course, Dr. Mulligan also wasn't there on February 24, 2018. He didn't witness what happened. Dr. Mulligan testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulligan is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulligan testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulligan said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulligan, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulligan thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulligan's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar. That is you'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulligan testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claimed scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay, that's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show and we'll show, this was played for the jury before. It's Cardi's testimony, plaintiff's testimony, as to how she was supposedly cut by Cardi.
When you say it like this, she put her finger.
Pointing, yes, go like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulligan's testimony that it was a right-handed person who scraped with an index finger and two other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claimed scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulligan says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with the straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulligan says that in his professional opinion, and counsel talked about how well respected he is, that it was a right-handed person who scraped three fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulligan to testify that a left-handed person might have made the claimed scar. But that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulligan testified that he can't say when plaintiff got the claimed scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulligan. And Dr. Mulligan also testified that he can't say whether the claimed scar was caused by an intervening accident or some other cause.
Judge, in this case, testimony.
Ladies and gentlemen, you heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulligan's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session in his mind is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulligan testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or microneedling. Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulligan also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulligan, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulligan also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulligan. Dr. Mulligan knows that he is going to get paid, if at all, the $17,500 only if his testimony helps plaintiff recover money in this case. That is a big incentive. And because of that risk, that's why he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018 she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned, she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots.
No, he did not say. Cardi referred to her as security heavy.
And starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm, and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
I can stop there if you want.
Okay. All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30.
All right, chat. So they are gone on their lunch break. So it appears that we are going to come back with Cardi's lawyers continuing their closing argument, and then the struggle lawyer is going to come up with his rebuttal. So that's going to be interesting. In the meantime, in between time, let me give y'all my synopsis of this, what we're looking at, some of the legal claims that they have brought up on the defense's side. So with Cardi herself, and also we could read some super chats to kill that half-hour time. All right. What he focused on, because I was taking some notes here, was really looking at a few things. One is Imani being consistent in her testimony? Because he brought out that chart, I think that maybe he's going to go for probably like 30 more minutes and show the jury what the inconsistencies were, right? Remember the screen they showed us that was like, it's like a slide. You had one side was had some bullets, and then you had another side with a different set of bullets. So I think he's going to walk us through all the inconsistencies witness by witness. Because you got to remember, I thought he had 3 more witnesses. There were only 9 witnesses in total spread over 3 days, Cardi B being witness number 6. So if we have 9 of these witnesses, he's going to slowly go through each one, because that's what the struggle attorney did, right? But I think what he's doing that's brilliant here is that Imani had a lot of inconsistent statements. I talked to you guys about the hand thing, right? How Imani is on video saying that Cardi B put her finger in her face like this, but then the doctor, the plastic surgeon, says that 3 fingers were used to cause the injury that she has. The other thing is this woman has been in 2 car accidents following the incident. How do we know that that wasn't caused by anybody else? The other thing is there's no witnesses. Nobody saw it. Nobody saw it at all. So if you have no witnesses, no security footage, how can this jury determine that Cardi B was a proximate cause, or she was the causation of these injuries, and she should be, Imani should get those damages, right? The other thing that I really love that this attorney did is he says that immediately following the incident, what did Imani do? She didn't go get help, medical attention. She didn't take a picture of the incident. She spoke to her family, and then she went home and took a nap. That's what she did. Like, she went home and took a nap. Out of all things that you can do after an alleged celebrity attacks you, you go home and you take a nap. I guess you were done for the day, right? Down for the count. Down for the count. The other thing that I love that he said is he focused on what Imani said in her own testimony, her own words, right? He's going to find the intricacies with that and the differences and the discrepancies, right? The other thing she said is it kept changing. Did Cardi, scratch you on your cheek or your nose? The nose thing came out of nowhere. We started hearing about this mysterious scratch on her nose, right? Now, when you look at the picture where she went to the plastic surgeon, we didn't see any injuries to her nose, just that one scratch that was on the side of her face, right? Now, it's interesting because in her lawyer's presentation in the closing argument, he said the only reason why Imani selected that plastic surgeon was because he was one of the only doctors that she could find that would perform the plastic surgery on a lean basis. You have to remember, Imani was fired from her job. Then she filed a workers' comp claim. Imani didn't have the money to pay for the procedure, right? So if you're shopping around, you're looking for a doctor that will do it because they know that you're about to go to court. And if you are awarded the money, then he'll perform the procedure. Now, here's the issue with that. She's probably going to lose this case. She's very likely going to lose it. Now, that doctor is now out of $11,000. What Cardi's attorney did here, which was brilliant, is he focused on microneedling. That's in our video that we're going to release today, and also in our our recap for later. Because microneedling is a procedure, but Cardi's attorney was right to point that out. You can get microneedling done in another place for far less than $11,000, right? The fact that he charges that amount of money for microneedling is crazy work. It really is insane. It's not normal. That's not what you see when it comes to estheticians and things like that. I think it's like less than $1,000. I mean, it's not $1,000. It's not $11,000. Here's what he said during his testimony. That's crazy. He goes, it was technically a surgery because I had nurses, there was general anesthesia, there was topical anesthesia. And whenever there's a doctor of my stature with nurses and anesthesia, that is considered a surgery. So this is a surgery that she could not herself afford. That was done on a lien basis. And same thing with the other psychiatrist that I don't think he's gotten to the psychiatry part yet, but the person that she saw through her workers' comp claim, she did mention that she felt guilty about doing all of this, right? So I think he's just now starting to warm up the oven and cook a little bit more. But he started with focusing on Imani's behavior, right? And then how about that before they took their break earlier, that Imani's granny is talking to one of the jury members. I think she did. I think she did. They just don't want to sanction the old lady. But she was surprised. The judge was like, hey, you, ma'am, you know you're still sworn in, right? And she's just like, yeah. He's like, did you talk to a jury member? They're not supposed to do that. They're not supposed to do that. Whenever there's a trial happening, no one is supposed to speak to the jury members except for the bailiff and the judge. Attorneys can't talk to them either, right? These people have to make a fair and impartial decision. Now, here's the thing, and that's different when it comes to criminal trials versus civil trials like this one. One of the big things that we see as a differentiator is the way that the jury has to look at the evidence. It's called the preponderance of the evidence. They don't need to prove everything, right? Because that's clear and convincing evidence. That's what we're used to seeing in criminal trials, like guilty beyond a reasonable doubt, right? Prove it. Here, it just needs to look like preponderance means like 51% can tip the scales ever so slightly. 51. That's why they say the one. The one needs to be there too. It can't be 50-50. It needs to be 51% that something happened here, that Imani is telling the truth. But without photographs, the date of the incident, without security footage, it's just Imani's word. That's all we have. You saw her attorney penny pinching, like, please, sir. Like, please, sir, more soup. Like, give us something. But it got so bad that he said, at least give her what her medical expenses have been. And then there's more dialogue about, and we've learned this in civil procedure as well. When you look forward to the future, when they're trying to determine how much damages to award a plaintiff, they do look at life expectancy. In this case, the only reason why they came up is because of intentional infliction of emotional distress, and it impacts her ability to work and blah, 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 all the shenanigans, right? Now, they said she's 32 years old. She could potentially live to the age of 80. So we need to consider that this emotional disturbance can continue to impact her until she's 80 years old. Can y'all believe that? Can y'all see the reach? The reach. It's such a stretch. It is such a stretch. I mean, I still can't believe it. It's 4:07 Eastern Standard Time, 1:07 in the Pacific Time. They are due back in about 23 minutes. I'm going to go ahead and read a few Cash Apps and answer any questions y'all have. We're going to come to the community to see how y'all are feeling. We do have a poll up, and here's a question that I asked y'all. How long will it take for the jury to deliberate on the security-heavy case, right? We have three options for you. 61% of you guys say less than 4 hours. I don't know if they're going to get a verdict today because, we might need to adjust this, because if it's 1:30, he might need a half hour. Struggle lawyer might come back for a half hour. That puts us at 2:30. I mean, it would give them an hour and 30 minutes of deliberation time, which, I mean, 61% of you guys think it will take less than 4 hours. End of the day, I don't know. It's a little questionable. It depends on how fast they move. Otherwise, my projection is tomorrow morning. Tomorrow at noon, I think. That's when they're supposed to start. So I think tomorrow morning we'll get it. But that is what's looking likely with the time that we have right now. So some of y'all are, how about this? Let's do a social poll. If you think it's going to be today, type today. If you think it's going to be tomorrow, type tomorrow. I want to see what y'all think, because there's just not enough to prove that Imani got these injuries from Cardi herself. You know, I do like that this attorney also mentioned that Cardi B was pregnant at the time and the reason why that pregnancy was concealed. Okay, Craving Spirit says tomorrow. Kurt says today. Pam says today. Chandala says tomorrow. Slytherin Dragon says tomorrow. Isabel says mañana. Yeah, and I would have assumed it would have been today if they had more time to deliberate. But now that I'm looking at the clock and talking out loud, I'm thinking that they might not have enough time today. So it likely could be tomorrow. So you guys are pretty split. I see some today, some tomorrows. Ari's like, this case is bogus. It is. I mean, this is crazy. But at the same time, you also witnessed the worst closing argument of all time. All right, let me catch you guys up on Super Chats. It is 4:09. They are back with us in about 21 minutes. So we're going to kill some time as they are on their way back. Shout out to D, who hits me with a 2, says AV7 doing super stream Saturday. Oh my God, y'all. I was so tired. I watched 3 days of trial in one day. We started at 12. I ended at 9. And some of y'all were there with me watching the trial. We watched all of it in one day. Got it done. Boom. Just boom. Got it done. So it was interesting because I thought it was going to be a lot faster than that. But I'm happy that we did do that before coming back to court today, because now I know the case very, very well, right? We also got a chance to see every single witness's testimony, some of which really didn't add any value, like for her to bring her granny on, like Imani bringing her granny there, Imani bringing her mother there, because they spoke to her on the phone after the incident. If you really think about it, she had what, 6? She had 6 witnesses altogether. So that means, yeah, let's go through it. So you had Imani herself, then you have Imani's mother, then you have Imani's grandmother, then you have Dr. McKenzie, right? That was the workers' comp lady. Then you have Cardi herself. And then, sorry, I'm missing the plastic surgeon. And yeah, the plastic surgeon. So 6 witnesses. I don't know why they would call Cardi, right? But that she had 6 witnesses. Of those 6 witnesses, the only people of value, I'm going to take Imani off the board because I don't think she's telling the truth. I'm going to take her mother off the board. I'm going to take her grandmother off. So then that leaves us with 3. That leaves Cardi, plastic surgeon, workers' comp lady. Of those 3, 2 of which are lean people. And at the end of the day, if Cardi is telling the truth, that did not help Imani's case at all. So she has a weak case. It's very weak. So I'm really happy that we did that epic Saturday stream. Y'all took care of me, sent me cash apps and things. And then immediately after, I got myself a nice dinner. So I really want to thank all of y'all for supporting Saturday stream. It was definitely a long one, but thank you, D, for the super chat. Coming back, D hits me with another 2, says hard work and discipline beats a cash grab. It sure does. It sure does. Like, she has another job. And what did her attorney say? She wants to move on. She just wants to close the door on this and move on with her life. Well, move on. Are you going to get $24 million of moving on? Oh, and then her struggle lawyer said something about, oh, we never said we wanted 24 million. Do you know what? When you fill out a complaint, right? this is a lawsuit, civil lawsuit. When you fill out a complaint, the very last page of that complaint, you have to put something called a prayer of relief, right? What that means is what you're asking the court to do. If you're saying you want damages, monetary damages, you have to tell us the dollar amount, all right? If you're saying you want punitive damages, that means that you want to charge the defendant and they should pay an additional amount of money for what they did. Those damages are designed to punish. So at some point, because why is Cardi B gonna make up a random number? Why would she make up $24 million? Like, I doubt that she would. Because what person would want to look at their net worth and see such a big amount of their net worth given to a plaintiff? And knowing how he did his closing, I guarantee that man put it in the complaint. Matter of fact, I should pull it up. When they come back, I'm gonna see if I can find the original complaint and find the document. I might have it. Why do I feel like I have it on my phone or something? Because I was making a TikTok for y'all. I might actually have it. In fact, I do. It's a little blurry. It's proof of service of summons. I have the summons, but I want to see the original complaint so I could see the money in there. Yes, it's proof of service. This guy's law firm, which is across the street from the hospital or whatever. Yeah, this is the service of summons. So it showed the summons, the complaints. There was an ADR package. So basically trying to settle it. So there was a settlement package. There was a case cover sheet. No cross complaint. And then any other documents. I think the only other document was a notice of a case assignment. So yeah. I can't believe that, chat. I really can't. Shout out to 2 Minutes Approved who gifted 10 memberships. Thank you, 2 Minute Approved. I did shout that out in the moment. One thing that's super great about this community is we always give back to each other. 2 Minute Approved came out. Me as a creator, I get 10 memberships to give out to you guys as well. So your girl joined in. I gave out my 10. I try to do it on the first week of every month. So it reset for September. And I gifted y'all the 10 memberships for the month of September. Shout out to Miss Pam Salters, been with me for 9 months. Says blessings, everyone. Please hit the like button. Yeah, you guys got my likes looking okay. Looking a little raggedy, I'm not gonna lie. I mean, your girl cooking, giving you a lot of legal knowledge. I think you can hit the like button for me. But thank you to those that have hit it. And thank you, Pam, for the reminder. Senator hits me with the 5, says, AV, did you get it? Also, this case is pure comedy. It is hilarious. I mean, and then you add on that closing argument from the struggle attorney. I mean, you can't make this up. You cannot make this up. What Senator is talking about is he has a candle business, sent me a candle. I do need to pick it up. But this morning I was very busy with Vid Summit. For those that missed it, I am speaking at Vid Summit this year as a speaker, and I'm going to be teaching other creators how to create on this wonderful platform that we call YouTube. So because of that call this morning, I didn't get a chance to get out and grab the candle. But as soon as I do, and likely since we'll be here tomorrow, I will try to grab it before tomorrow's stream, light it for y'all so y'all can see Senator's great work. Shout out to D with another 5, says trying to get 24 million off of 500K or 50K case is a bad idea. Just saying. I mean, because think about it. What happens to Imani and her attorney after this? Cardi went viral last week. So this his reputation is already shot. And then before Cardi's team started doing their closing argument, they were talking about placing a bar complaint against this lawyer for ethical violations. That is also being broadcasted across the world. We just saw that. His reputation is bad. Imagine if he is handling another one of your cases and this is your lawyer and you see him on TV. It's not looking good. It's not looking good. 4:17 Eastern Standard Time, 1:17 Pacific. They are due back in about 13 minutes, guys, and they will continue the closing arguments. In the meantime, in between time, we are reading super chats. Again, huge shout out to Nature Self Study who gifted 10 AV memberships. Thank you, thank you. I saw a lot of people saying thank you in that moment, but yeah. Amazing. Shout out to Nature Self Study again with the $50 super chat. I appreciate you. And Nature Self Study is a cross between a future lawyer and a future doctor. I haven't seen that combo. So that is a unique combo. I mean, I wonder what you think about this case, because like we're seeing some issues with a doctor that's doing things on a lean basis, like getting paid that way from, his clients in his practice in that way. $11,000 for micro needling. Like what? I'm curious of your thoughts. Nature Self Study. Shout out to D with the 2 said, did the bar you passed serve drinks, sir? I mean, one of y'all was like, is he drunk? Like the questions he was asking, he was stumbling over his words. I don't think that was nervousness. I don't know what it was. But that was, and he kept going back to his notes. It looked like it wasn't rehearsed. It looked like he didn't practice. We've seen some great closing arguments on this channel. We really have. But that was not it. That was not it at all. I mean, even, sometimes like with some cases, you are pro defense or you're pro prosecution as a viewer, right? And we see that in Donna Adelson. I had to skip that one today because I knew closing arguments is going to happen. So I was like, nah, we got to be there for Cardi. But, a lot of people in the Adelson case are pro prosecution because it really does look shady. It really does look like that family set up poor Dan Markel to get killed. Like that looks like a pro prosecution case. Or, if it were civil, it would be pro plaintiff. Here, I mean, this is looking like pro defense. We saw that with YSL, a few other cases too. This is definitely a pro defense case. I could see that. And the fact, and remember this, chat, the fact that the jury asked questions and like after almost every single witness, I think 70% of the time they had questions for, whatever witness was on the stand. So that means I think they're leaning more towards not giving this lady a dime. Like I'll keep it 100. And I think that the struggle lawyer knows that. That's why he went towards give her past amount of money. And whatever you think she should get for her pain and suffering. What pain? What suffering? Insomnia? PTSD? Anxiety? Because Cardi B and you got into an argument. So I don't know. And then for her to, to talk about this cut, and that's the thing. If you don't have proof, where did the cut come from? There was no bleeding. How'd you get a cut? I don't know. This whole thing is just insane. 10 minutes left, guys, before they are back. Let me keep going. Coming down the line here to Too Adorable with the 2 says Cardi and that girl both need to sue that lawyer. I mean, imagine how this woman feels. This is her attorney. And he's also talking about like discharge. Like it's so embarrassing. I want to see Amani's face. All we can see is the back of Amani's head. But I want to see Amani's face as like all of this was being read to the jury. We couldn't see her. It's crazy. But thank you so much, Too Adorable. Really appreciate you. Shout out to Kim T with the 10. Kim says, I feel like this is such a waste of time because this lady is going to lose this case. She is. It's absolutely ridiculous. It's a total cash grab. Yeah, our prior poll before this one, I think this is when we first started. I asked you guys, is it a cash grab? And I think 80% of you all thought it was a cash grab. It's crazy. It's the world we live in. Shout out to Bullet in My Beard with the $6 here. It says, if I didn't know better, I think Cardi attacked her with a knife and an axe. I mean, the way he was explaining it, like the pain, the suffering, the intentional infliction of emotional distress. And it's like out of all of the torts and all of the things in personal injury law, IIED is the most annoying because how do you sum up somebody's pain and suffering? The emotional distress that followed an event, right? So Bullet in My Beard gets it. Like we're all thinking the same things. Like what the hell? Shout out to Zoe again, your stream sponsor, sponsoring today's stream. Super generous with a $100 super chat. I had you guys spam her name. This is very generous. She is sponsoring the debauchery that we are watching. I mean, I can't believe it. Like Cardi was falling asleep. She, that power yawn, like she had the power yawn going on. Poor woman's away from her kids and her family. I think, I don't know if it's confirmed, but people are saying that she's pregnant now with her next child. So culture at home, the other kids are at home. Like, what is going on? Right. So this is her 4th day in court. Shout out to Kelly Applegate, who's been a member for 10 months, says over here with Viverito in the bush. Listen, there's so many things going on with the YSL case. We're gonna see what happens, but like Thugga has been in the news. And again, for those that missed it, Woody had a pretty bad accident over the weekend. He's recovering, so we're all glad that he's okay. Shout out to Penny Petty Pendergrass with the 5, says got my bagging and tagging shirt on. Yes, thank you so much. Yeah, we do have I do have merch. I was doing some work to it, the merch store this morning. I have the vision in my head for at least we're gonna get a Cardi B shirt. And I think that shirt should be security heavy, right? So I have the design up here. I just got to put it on paper. And hopefully before our stream tomorrow, I will have it done. Usually whenever we watch trials, we'll give away some merch. So definitely as the verdict comes in, I'll make sure that we get that up. Because a lot of y'all were like, if you're selling security heavy shirts, I want one, sis. So we will put those up. But y'all asked for it on Saturday. We were thinking of what the ideas could be, but it seemed like security heavy is a popular one. We have, shirts from the ASAP Rocky trial. Like I think at one point, Joe Tacopina asked the question to ASAP Relly while he was on the stand. And his answer was yes, no, maybe. I don't recall. He said all 4 answers. It's like, well, which one is it? Yes, no, maybe. I don't recall. And then the infamous Little Woody line, I don't recall. You made a song about that, I think. I think it's one of his singles. It's called I Don't Recall. Shout out to Suarez. I hope I'm saying your name right with the 2. Says fingernails, not acrylic nails. Oh my gosh. That's how you can tell this attorney doesn't know what he's talking about when it comes to nails. I mean, think about this. And ladies know. When you have your natural nails, they are slightly thinner than acrylic nails. Acrylic nails are thicker. It's actually harder to scratch with acrylic nails than it is with natural nails, right? Even if you got like gel, right? Like a gel manicure, that's a little bit on the thicker side too. Some people do dip. That's also on the thicker side. Any enhancements that you make at a nail salon to your natural nail is going to be harder to scratch with. Unless, and Cardi B talked about this when she was on the stand, unless they are shaped differently. So for example, sometimes you can get acrylic nails and people, when they're filing, if they did it in like a square shape, sometimes that square could be a little bit too sharp. So most women and many people that, like nail technicians, they know to slightly round the corners. Otherwise, you're going to take somebody's eye out. The other thing that this struggle lawyer said in his closing was that she had, rhinestones or those like gemstones or whatever. Now, Dr. Finke did say that those were flat. And even Cardi B herself says they were flat, right? So if the nails had like enhancements on them, and she said that they were like square coffin shaped, we would be able to see what her nails look like on that day. At the start of the stream, struggle lawyer gave me a headache because what he tried to say is the day of the incident, Cardi B was also in LA. Not only did she go to the doctor, she also went to an all-star basketball game. So there's pictures of her that day at the all-star basketball game. And so he wanted to zoom in on that photo and see what her nails actually looked like on that day to see if she was telling the truth about the condition of her nails, if they broke, things like that. Now, Cardi being running around with broken nails. Not going to do that. She gets photographed way too much. She's not going to be like photographed with a missing nail or a broken nail. And ladies know, like if you get gel, like sometimes we start, like picking it off, it gets bubbled, that's the worst thing. But Cardi B has acrylic nails, and I'm pretty sure if one broke or whatever the case may be, she ain't gonna be going around like that. Sometimes she talks about having press-ons and wearing those press-ons. And I'm giving y'all a lesson. Like men are just like, oh my God. Press-ons flip off when they're pressed off. They're pressed on, but when they're pressed off, they fly, so all those things are interesting. But sidebar on the nails. It's 4:28 p.m. East Coast, 1:28 their time. They should be back in about 2 minutes as we are catching up on some super chats. Shout out to Loves Curly Hair with the 5, says, I don't think she should get anything, not even for the medical bills. Yeah, I mean, I don't think anybody is siding with this girl. Like Cardi, you even saw Cardi B like looking at this man as he was delivering his closing argument when things were not true. There were some contradictions in his statements. He said that Cardi B was swearing, that she was being disrespectful here in this courtroom. Well, her lawyer cleared that up and was just like, hey, all she was doing, he asked her to repeat a statement. She just repeated his statement. Do you see how that works? And he goes, I was swearing too. Am I not professional? So I think that Cardi's team did a really good job with that one. But I agree, Loves Curly Hair. The medical bills, like they're past bills, but that was also your choice. Given your circumstances, did you need to go get plastic surgery right away? Did you need to pay actually, it's not paid. Did you need to rack up an $11,000 plastic surgery bill? She didn't. That's a choice. And I know the jury's going to talk about that because she purposely went to find a doctor that would do it on a lean basis. When I say lean, I don't mean like lean, like we lean it back. I mean a lean, Lien. So placing a lien on something. So that's the shenanigans that that we have to look at here when it comes to how she found these doctors. The other thing is you got fired. You didn't tell your family about that, right? Instead, you talked about, the fight, the alleged altercation that you had with Cardi B, but you didn't tell your family you got fired, and then you file a workers' comp claim. Crazy. Why workers' comp? Because you want some shmoney. You want to be able to be paid, right? You were injured on the job. Were you? Is a scratch an injury? But think about that. In response to the workers' comp claim, she needed to be evaluated by an approved doctor. And when I say doctor, this is for emotional reasons, right? The insomnia, not being able to sleep, the anxiety, the PTSD, the shock, the horror from all of the things that happened. This altercation with Cardi B was just so hurtful. She didn't know what to do. She didn't know what to do. She used to be a fan. The other thing that Cardi's attorney said in his defense's closing argument was, if this person is working security for the whole building, how ironic was it that they weren't on patrol, that, Imani couldn't have been on another floor. She was here. So interesting stuff. And she did wait long. Some of y'all are saying it. Deshonda says she could have gotten a BBL for $11K. I mean, maybe less. Like, I don't know why she would wait this long. I mean, it's 2025. Let me look at that. When was this filed? When was this summons delivered? Is there a date on here? Proof of service summons. I don't think there's a date on this document. It's just proof of summons. I was gonna say, wait. That's a little blurry. I gotta look, but this happened in 2018, right? But the plastic surgery didn't take place until after the pandemic, he keeps harping on 2021, 4 years later. Also, she didn't go to the police. She didn't file the lawsuit sooner. She didn't take pictures of her injuries the day of the incident. She admitted herself that she didn't intend to sue. I don't get it. I don't understand. 4:33 guys, 1:33 their time. They should be back any moment now. But yeah, I don't understand it. Shout out to Deshonda again with the 10, says AV, I got my whole face micro needled for 180. Oh my God. Think about that. And Imani racked up a bill for $11,000. $11,000 for microneedling. Deshonda said, I paid 180, okay? Like, that's it. After her car accidents, Miss Jams. Thank you again, Deshonda. After her car accidents, it's such a hard sell. I'm really curious to see what this jury is thinking. Thank you so much. It looks like we got a few people on the Cash App. We'll go to Freddie first. Freddie hits me with a 5. Thank you so much, Freddie. He says that lien going to be applied to her house, condo, etc. Yeah, that's the thing. You know, I used to work a lot with the lead attorney, and we would talk to y'all about that. Attorneys have liens too. Attorneys can place liens on people's properties if you don't pay them. Let's say you don't win a case or whatever, because in personal injury, usually there's a third of the award damages that go to the attorneys, right? It's usually a third. So this guy is probably, if she couldn't pay her doctors, she's likely hasn't paid him. And that is why he wants to win so much. That's why people call personal injury lawyers like ambulance chasers. And in this instance, I don't know if y'all remember it, but Dr. Finke's office is actually across from this lawyer's office. And this lawyer, Amani's attorney, would go and try to talk to, he's been trying to talk to Dr. Finke and his staff for years about this case. It's been 7 years. Dr. Finke was like, I'm not talking to you. They never talked, but this attorney would leave his business card. He would send other people. He was trying to get intel on this case. Dr. Finke did amazing on the stand. But yes, service liens, Ace Boogie, service liens. But yeah, it's almost like he was like itching and scratching for the bread. Like, what's the woman's name from Friday? Is it Felicia? He was like Felicia from Friday. Shout out to the Jason Whitaker podcast, Jay Witt with the 5. Thank you so much, brother. I saw some of your videos over the weekend. You're doing great. Great job on the channel. I think you had an attorney on recently. Y'all check out the Jay Witt podcast. I have to get used to saying it because in my mind, this is Darewall Christian. You know, that's how I recognize the channel. But he has rebranded. Any of the mods are hanging around, please check out his channel. Is amazing, brother. He was around when we were covering the YSL case. I think he went to the courtroom one day and we were all watching. We're like, hey, it's Darewall Christian. It was so amazing. So it's great to see you, brother. And congratulations on the YouTube growth. He says, you better not use this for micro needling, AV. Great commentary, friend. Thank you so much, brother. I appreciate it. Yeah, they're 6 minutes late. They started court late. And I was like, I had a feeling because Cardi B, it's probably tough to get her around crowds. There's probably people outside of the courthouse looking to get pictures, paparazzi. This is in California. It's the land of paparazzi. So, they ended up starting the proceedings without her, meaning like just more of the preliminary stuff she didn't have to sit through. But she did get there late. They started probably about an hour 15 minutes late. So the judge said that they would be back 7 minutes ago. So we're just waiting. We're hanging around. I'm just reading some of y'all comments here. Petty says, AV, there is a clip of a lawyer in this comedy movie that sounds like Imani's lawyer. The movie is Big Stan. You'll love it. I have to check that out. That would be amazing. DJ Plays Jr. said Cardi just threw a marker at a reporter. Stop playing. She throws things, y'all. She throws things. Like, didn't she throw a microphone at somebody recently? Cardi's got a little temper. You know, she's a little hot. Miss Jam saw it. TMZ deserved that. Where's this clip? What do y'all have? Hold on. Let me see. Let's see if we can find a clip somewhere. Cardi B throws marker. Okay, yes, TMZ. Cardi B angrily throws pen after being asked about Offset. Well, it says Cardi B throws marker at reporter for disrespecting her. I found something on IG. Let's see if we can find the clip. I see her walking outside the courthouse. Let me bring this to y'all. Let's switch to this tab instead. Let me set it up. Let's watch it because I haven't seen it. Oh, oh! It says this video has no sound. Oh, yo, she sure did. She sure did. Oh yeah, she's going off. Okay, she's saying we can't hear it though. This video does not have sound. I'll see if I can find another one. But she definitely did throw a marker at a reporter. She definitely did. That happened. All right, here's something happening in the courtroom, like with sound. It just cut off. So hopefully they are back in a second. She threw a Sharpie. She has, well, I don't know. Are they gonna sue for 24 million? Yeah, I'm trying to find the clip with sound. That's the first thing that comes up on Google News. Let me see if I can find y'all another one. Because it looks like she is kind of swearing. But here's another one. 24 minutes ago. Oh, this one has sound. Let's go.
Hey, Cardi, you're beautiful.
Thank you.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me.
I got
How you feeling?
Cardi, your court look is amazing. Who are
You're
you
amazing,
wearing?
Cardi. I still love you, even though you just threw some stuff at
I
me.
don't care. You're disrespectful. Don't do that. Do you see women asking those type of questions to me?
No,
You see
ma'am.
women asking those questions to me?
It's a legit
Why
question.
do you feel as a man you got to ask me those type of questions? Act like you have some manners. And your mama taught you, respect women.
Well, damn.
Somebody hand me my marker.
That's right. It's New York all day.
I appreciate it. I still love you, Cardi. There you go.
He said, he's like, I still love you, Cardi. She said, no, you don't. That's crazy. That's crazy. I got to stop screen sharing for a second, just because sometimes when we toggle between tabs, it will take the audio off. And I just got that error message. So let me start screen sharing again. Stop screen share, start it again. But yeah, she absolutely threw that marker, and she let him know, like, you need to have some respect, and y'all need to start respecting women. Which, I mean, she's not wrong. She's not wrong. If she is pregnant and Offset is bragging about getting her pregnant for the 3rd time, I mean, that was a little bit of a low blow, or, you know, a strange question to ask, especially if she is literally trying to fight this case. This is a civil lawsuit. But was it right of her to throw the pen? like you better act like your mama taught you some manners. Was it right for her to throw the pen? What do y'all think, chat? Was that too much? Was that too much for her to throw the pen at the guy? 4th time. I said that wrong. Sorry. I've been streaming. We've been up here for 3.5 hours. Yes, it was. Yes, ma'am. Okay. Now he's going to sue her for busting his head with that marker. I mean, that's the other thing. Did she have to throw the pen, or could she just have said that? Like, hey, don't ask me those questions? Because I think she has a point. Are women asking her those type of questions? So I don't know. I don't know. But at the same time, it's not the first time Cardi has thrown items at people. Now, here's another question. If she's on trial for losing her cool with another woman, did that just help? Oh, did that just help? Did that just help? So I don't know, chat. I don't know if that was helpful or hurtful. I mean, the jury's, they haven't even started deliberating yet. But hopefully this intel does not get to them. They're not supposed to be looking at the news, talking to anybody about the case. We know that that's always bullshit. They do it. But this is a 50-50 thing. I mean, we might have to do another poll. We might have to do another poll now. This poll, let's end this poll. It's been up for 2 hours. How long will it take for them to deliberate on the security heavy case? It looks like, that this poll is invalid anyway because they're running out of court time and fastly running out of court time if they were due back 13 minutes ago and they're still not back. So if they're still not back, then that should tell you guys something. And she was getting in the car. Where was she going? That was a few minutes ago. Where was Cardi B going? Is she leaving for the day? I just thought about that. Hold up. AV about to put a poll up. Thank you so much for the line mail. Okay, let's read it. So how long will it take for them to deliberate on security heavy? Let's just say that collectively y'all are at 85% that it would be today and 16% tomorrow. So I'm going to end that poll. Thank you to the 1,000 people that voted in that poll. Appreciate it. You know what's so crazy? 1,000 people voted in the poll and I only have 600 likes. I mean, how? Y'all will vote but not hit the like button? Man, listen, all this legal knowledge, you can't give your girl a like. I know sometimes people forget, but I got 600 likes and 900 people in this joint. Okay. Somebody said she's going to Wingstop. I hope not. Let's start a new poll. All right. So did Cardi throwing a marker because, let's make sure we get it right, a reporter asked about, I don't know if I have enough characters, asked about Offset plus pregnancy look good. Yes, no, I don't recall. No, I'm kidding. Yes, we'll give you that option. No. I'm going to put it was justified. Because some of you guys are saying she's hormonal, she's pregnant. That was an inappropriate question. Some of y'all are of the opinion that throwing it is childish. So I'm just looking at what y'all have said in the chat. Okay. Yes, no, maybe. I don't recall. Where are these people at? Okay. Like, I want to see the rest of the closings. It's 1:45. They're late. Let me come over to Live Crimes chat, see if anybody is in. I don't know, after lunch break. We still on HIPAA. People are talking about HIPAA all up in there. Okay. It doesn't look like we have any eyes on the ground. I'm going to check Twitter as well. Sometimes we can get a better understanding of who's there when they are on Twitter. Look, where y'all at on the poll so far? The new poll. Did Cardi throwing a marker because a reporter asked her about Offset and pregnancy look good? 59% of you guys say no. Wow, I spelled that wrong. I spelled about. You know what's happening? The B on my keyboard keeps getting stuck. Does anybody know how to fix that? 57% of you guys say that it was not a good look. 8% of you say it was a good look. 36% of you are saying that it was justified. 93 votes so far. Red is like, put some respect on Cardi's name. I mean, I do think that it was good that she checked the guy, but it could have been good without the marker throw at a trial where temper is on the table, right? Shout out to Miss Kelly Kell, our favorite 3L. She is in her third year of law school. She might have just started the semester too. She is gifting 10 memberships in the chat. If you have received a membership, please tell her thank you. Miss Mal received a membership. Little Rock received a membership. Tay Marie received a membership. Mars got one. Crystal got one. Choose Compassion got one. G-Man got one. Love is not admissible evidence. I like that name, got one. LVZ got one, and Little Rock got one. Odious as well. It was fun. It was fun. Shout out to Kelly Kell, who was here the other day when we did that marathon stream. 9 hours, guys. 9 hours. It was a lot. It was a lot. So we are all caught up on our super chats and cash apps and all that stuff. We're just waiting for them to come back. They're 18 minutes late. So I think what we can do in the meantime is run it back and go back to the funny moments of the trial when Cardi was on the stand. So it's going to be a recap of me, right? Because we have a shortened version of that, but we're going to wait until they come back. I will keep the trial feed open. So until they are back, I mean, it's a great way to kill a little bit of time. But yeah, we're having a debate right now on her temper, right? Like that just happened. And shout out to you guys for letting me know that it just happened. But yeah, it looks like she does get triggered pretty easily. Definitely. Shout out to Petty Pendergrass gifting to the membership family as well. Sent out 5 memberships. David Hunt got one. Ari got one. Young Forever received one. Aquarius Girl and Healthier You with Mel received one as well. Really happy that you guys got those memberships. Just waiting for them to come back so closing arguments can continue, the rebuttal can continue, and we can get back to the case. Getting a few notifications. Y'all are finding us on TikTok. All right. That's the other thing. I'm waiting for the case to be over so I can go over there and remind people like what's going on. What's going on? All right. Let me pull up while we're waiting the best of Cardi B on the stand. These are little viral moments. We did this ourselves and put it out last week. Y'all really enjoyed that video, so we're gonna take a peek at it. So let's go to my own channel, AB to the 7th, and we're gonna check that out as well. Okay, I was dying. It was so funny. This was hilarious.
Face chest to chest.
All right, here we go.
We were discussing yesterday at the end, we were talking about the issue
Weird,
where
looking at myself.
you testified that Miss Ellis was recording you with her cell phone. You remember that?
Yes.
Okay. Do you know what type of cell phone she was using at the time?
I'm not quite sure. I just remember it was square.
What color was the cell phone?
It had a case. It definitely had a case. But I'm not sure.
Do you know if the type of phone that she was using when she was recording you, would a light go on or would some kind of noise?
It didn't have a light. It didn't have a light.
So if the cell phone was facing Miss Ellis, I'm assuming it was. Well, let me ask you that. Was the cell phone that you're talking about, was it facing you or was it facing Miss Ellis?
The camera was facing me. When I got off the elevator, her phone was here. Then when I was walking and she was behind me, and then she said, "Oh my God, y'all, Cardi B, Cardi B." I looked back and the camera was like right there, like practically on her chest type stuff. I'm like, "Yo, why are you recording me?"
Okay. And you've seen like, police officers where they have a camera on the front of them. Have you ever seen that where a police officer will have that?
I never seen that, but that was her phone, not a camera.
I understand, but I'm saying, have you ever seen a security officer, police officer have a special camera on their chest which records what occurs in front of them?
Relatives,
I'm not saying she was recording you. I am asking you this question.
Mm-hmm.
If she was recording you, why does it matter?
Because she's a security guard and I'm going to a doctor's office. It definitely mattered.
You were causing a disturbance. Maybe she
I
wanted
wasn't
to
causing
record
a
you.
disturbance.
Time out. Let's not talk over each other, number one. wait for him to finish
Sorry.
asking the question before you answer.
Do you own the building of 8920 Wilshire Boulevard?
No, I was walking to a doctor's office.
Do you agree that you were a guest in that building? You were
Yes.
a visitor, correct? Yes or no?
Yes.
When a security officer tells you to leave, are you supposed to leave?
Objection.
Yes or no?
Sustained if that's been answered, cover this history.
You were causing a disturbance in the building.
She started the disturbance.
Did you also?
Ma'am, if you have objection, please wait.
Oh, sorry.
That should.
What's wrong?
Do you remember yesterday you said that there was a verbal altercation between the two of you? You remember that?
Yes.
Okay. And an altercation is a fight, isn't it? It's a verbal fight. You had a verbal fight with her.
Ask and answer.
Yes or no?
Yes.
Sustained.
You used the F word during that fight, didn't you?
Yes.
What other words did you use? Tell us in your own words what you said.
I said, bitch, get the fuck out my face. Why are you in my face? Why are you recording me? Ain't you supposed to be security?
Tell it to her
Why?
now. Go ahead.
Huh?
Say it again. Say it.
Objection, Your Honor.
You want me to say it to
I
her
want
face?
you to tell it to her face what you said on that day so she can hear it for
The
herself. again.
objection is sustained.
And Your Honor, do we have civility?
Yeah, why don't?
Yo!
Temperature down a little bit. You have actual questions.
Look at her face.
It's not time to argue with her.
What were the words that you used when you got off the elevator to this security guard who's no longer a security guard at this time?
Objection to argumentative and also covered yesterday.
It's been covered several times, so it's asked and answered. It's objection sustained.
So, Your Honor, I was told yesterday that my voice was too low by others, so that's why it's a little bit higher today, so that everybody can hear what I can say, as well as the witness.
I think there's a difference between volume and tone. I think the volume.
No, he's being disrespectful. He's being disrespectful.
Thank you very much, Your Honor. I apologize for that. I will try to do my best to tone it down. So, again, I will ask you to tell us and admit to this fact that you are not disabled, correct?
I'm not what?
Are you disabled?
At that moment, no.
Objection,
No.
Your
Are
Honor.
you disabled?
Overruled.
Are you disabled? Yes or no?
At that moment, when you're pregnant, I'm very disabled. You want me to tell you things I can't do?
What was your disability on February 24th of 2018? What was your disability?
I was pregnant. I couldn't protect myself, even if I wanted to. She's like twice my size.
No problem, no problem. Let me ask you this. How many
Counsel, you
months
asked a
pregnant
question,
were
you
you?
need to wait for the answer.
Okay.
You done, man?
How many months pregnant were you?
I was around 13 to 12 weeks.
Months? 4 months? 3 months? 3 to 4 months. Fair enough? Did you have a bulging belly?
No, I didn't.
Did Miss Imani Ellis know that you were pregnant?
Objection, cultural speculation.
Do you know if Imani Ellis knew that you were pregnant when you walked out of that elevator?
No, I didn't know. But she knows that I'm a patient. When you're a patient to go see a medical anything, you shouldn't even try to fight nobody. You don't know what disability they have.
Okay. Now, let me ask you this question. When you say you were disabled, were you disabled in your upper extremity, your arms? Were your arms disabled? The reason I'm asking is I want to make it very clear for everybody that your arms can go up and down, and they could go up and down now, and they could go up and down on that day as well. You agree to this?
Objection, argumentative, asked and answered.
He's wilding out.
And
He's wilding out.
I guess that's fine.
I'll let, you can answer this once. Please don't ask it again.
If my arms were disabled? No, my arms weren't disabled.
Can you raise your arms?
That courtroom lit up.
Can you? You don't have to do it physically. I'm saying, are you able to do it?
Yes.
And on that day, you were able to do it as well, correct?
If I wanted to, yes.
That's all I'm asking. Aside from your disability of being 3 to 4 months pregnant, do you have any other disabilities?
No.
Do you have a disabled placard? Are you legally disabled in any way?
Why don't you want counsel?
Now, when you saw Miss Imani Ellis and you got out of the elevator, not asking who did what, I'm asking was there any contact between you and her of any kind what that means is fingers to fingers, shoes to shoes, knees to knees, any contact between you and Imani Ellis of any kind. Was there? Yes or no?
No,
So she didn't touch you, correct?
no,
So if somebody comes here and testifies that she did do something to you physically, you disagree with that testimony, or you will, correct?
she didn't touch me.
Okay.
She didn't get to touch me, no. She was going to touch me, but she didn't get to touch
When
me.
you say she was going to touch you, how do you know that? You
Because
assume?
we were chest to chest at one point.
So then your chest did touch, right?
I'll say that, but you did say when I got off the elevator,
Okay.
we
Let's-
we walked a little bit. That's when we got chest to chest. When we got off the elevator, we didn't do no contact.
I understand. So here's how we're gonna do this. The date of the incident is February 24th of 2018. You agree?
Yes.
Now I'm gonna talk to you about the whole day. Not just the minute you got off the elevator. When I say the whole day, from the moment you got off the elevator, you saw Imani Ellis, you had your fight with her, whether it was verbal or not. At some point, she went away and you went away.
Mm-hmm.
So during that segment of time of your life, which was how many minutes in your opinion? 5 minutes, 2 minutes, 1 minute?
It was probably like a minute 45. It was so quick. It was really quick.
Perfect. So from during the 1 minute and 45 seconds.
No.
Mr. Cruz.
I didn't say 1 minute.
We haven't had a question yet. Please phrase one that's intelligible.
During the few minutes or 1 minute or whatever minutes it was that you were with Imani Ellis, during that period of time of your life and her life, during that segment, just told us now, during that time period, at some point, you were chest to chest. You agree?
Yes.
There was physical contact between her chest and your chest, correct?
Yes.
Now, when you have the chest-to-chest contact, at that moment, were you angry?
I was mostly nervous.
Were you angry?
Yes, I was angry.
How angry were you?
Depends on the level of angry, to be
Right.
honest with you.
Let's talk about the levels. I'm gonna go from a scale of 1 to 10. On the scale of 1 to 10, what was the level of your anger when you were chest to chest with this person?
Objection.
On the day of the incident.
Sorry, objection taken.
You were at a high level of anger when you were chest to chest with her, correct?
Objection regulated.
Overruled.
I don't think I was like on a high level of angry. I was more on a high level of concern, very concerned.
And why were you concerned?
Because I'm pregnant and this girl is about to fucking beat my ass. Hello?
So when she was going to beat you, like you just testified, what did she do to have you believe that she was going to beat you? What did she do?
She was on my face, chest to chest, and while we arguing, she's backing me. So we practically arguing, and I'm backing, and she's like walking forward.
Right.
Oh,
And she's, you said she's bigger than you, is that correct?
absolutely.
How do you know that?
I mean, look.
I'm looking, I don't agree with that. What is your basis? Are you saying she's physically bigger, she's taller?
I mean, you have her medical records,
I don't
right?
have anything. I want to ask you the question.
I mean, I was 130 pounds at that time.
Oh shit!
Overweight, right? In
God!
your opinion.
Oh my God!
Objection relevant.
She's a little.
You don't need to answer.
Okay. Did you make fun of her that she was overweight when you were there in the hallway?
I don't think so.
Did you call her fat?
No, I was calling her a bitch.
Bitch?
Yes.
Do you think that's respectful to call a security guard a bitch?
Objection.
Sustained.
Is that how you talk to everybody?
Objection.
Sustained.
Now, you said you felt I don't know the words. Let's go back to it. Did you feel scared, threatened, afraid at the moment your chest was touching?
Absolutely.
You were scared?
Absolutely.
And you had your cell phone on you, right?
I did, but she's in my face.
That's fine.
Did you focus on the question and just answer?
Did you use your cell phone to call Karan Newton, your security guard, who was downstairs?
I'm sorry, Chad. I just had a laughing attack. Cardi B is the best witness on the stand in 2025. Like, that's hands down. The year ain't done yet. Just give it to Cardi, man. Type Cardi in the chat. Type Cardi in the chat. I know we're talking about Adelson today, but like, this is amazing.
Okay, is 2 centimeters. You need to bring it closer. You can see it from there.
Objection, Your Honor, we went over this yesterday.
I'm sorry.
Hello.
2 centimeters. You know the size of 2 centimeters? How big it is?
That's an answer,
I have like an understanding of how it would be. Yeah.
2 centimeters. It's a little bit less than an inch. Okay?
Mm-hmm.
Now, Miss Imani Ellis had a scar to her face of 2 centimeters long, and she received plastic surgery for that. And my question to you is, did you at any time see a scar on Miss Imani Ellis's face, or a cut, or a scrape, at any time during the time of the incident?
No. And she couldn't get a scratch from me because I didn't touch her.
Chat. Look at, you guys remember the ruler. 2 centimeters is that small. This is why I didn't cover this case. It is that small, and she got plastic surgery for it. Okay? 2 centimeters. Right here. 1, 2. Dos. They are in court right now about that. All right?
Did you look at Miss Imani Ellis's left cheek at any time during the incident? Did you specifically look for that because you thought there might be a scar on her face? Or did you not look?
Objection. Compound and relevant.
Did you look at Miss Imani Ellis's face when you were arguing with her at the time of the incident?
I was looking at her face, but I wasn't looking like, she got a pimple on her face? No, I wasn't looking at her details or anything.
So if she had a scar on her face or cut, you wouldn't be able to know because you weren't focusing on it, correct?
Objection, calls for expert testimony relevant.
Assistant. Counsel, she's a fact witness. She didn't see a scar. 121.
You testified yesterday that when you go to get your nails done, you tell.
All right, so that was a nice little way to kill some time, but it looks like they are back, guys. So I'm gonna bring us to current day live. Let's do it.
So picking up where I left off, Cardi testified in this courtroom that the whole encounter was maybe 45 seconds, less than a minute. Counsel has urged, and I'll get back to this as well, that she didn't see what happened before, but if you add her and compare her estimates with those of Tiara and Dr. Finke, who said that it lasted about 45 seconds, it's clear that they came out right at the beginning. Now, Cardi also testified in front of you and under oath that she never spit on plaintiff. She never struck or cut plaintiff. She never touched plaintiff's face. She never used the N-word. She never threatened to get plaintiff fired. Cardi also testified that she is in fact left-handed, and we've talked already about how that undercuts Dr. Lanikin's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles. She lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA also. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the alleged incident on February 24th. That's absolutely untrue. She did not testify to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not in fact testify to is something that Your Honor that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently coffin square means the shape and the square and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy and they had no sharp edges. Apparently you can get little rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke, a fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which of course flat can't cut anything. And she testified, as did Dr. Finke, well, excuse me, I misspoke. She testified that they were flat. Dr. Finke, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have 2 witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that his client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault. And if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all of both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense, or that she cut plaintiff. The point he's overlooking is that is up to you. We've heard the evidence. We think it's overwhelming that Cardi did not touch a plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is an assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both Cardi's testimony, Tierra's testimony, Tierra Malcolm, and I believe also Dr. Finke. But let's talk about Ms. Malcolm. Tierra Malcolm, we called her as a witness, so we'll add her there. And she is one of the 4 people who were in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. Defense counsel has argued that, again, that she wasn't there in the beginning, but we know from her testimony that she was near the door, immediately ran out when she heard yelling. Now, we have a visual rendering based on plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that plaintiff showed you, plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them with Cardi behind her and with Ms. Malcolm facing plaintiff. The evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with the plaintiff. Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified, what Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not realize with Cardi behind her and plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head. Counsel has argued
Your
that.
Honor, I would object to him referring to counsel. We can talk about facts, not counsel.
Plaintiff's counsel has argued to you that Ms. Malcolm didn't know who hit her. Okay, and he dwelled on that a lot in his cross-examination of Ms. Malcolm. And with all the things flying, with all of plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head. But she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threaten in no uncertain terms to harm Cardi. Quote, "I will F your shit up." That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face to face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that since she testified here that she was using earphones. We've got another witness who says plaintiff was standing there, flailing away with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Cardi and Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked, what about chest to chest? And Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt the plaintiff was at fault and, quote, she handled everything unprofessionally, close quote. Now, we also called Dr. Finke. He, too, was there the day of the incident, and he, too, has no axe to grind. He is not her regular doctor and never has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NDA All-Star Weekend and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tiara Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling and he immediately ran to the front. Okay, so he gets there very quickly too. And he just has a little bit more distance to cover. And he testified, like Cardi and like Ms. Malcolm, that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway. And that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out. And also that Dr. Finke, once he got plaintiff to leave, which he refused to do, that he went back into the office. So he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood in her face from a scratch that supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there when plaintiff expressly threatened harm to Cardi by saying, "I will F your S up." Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting turn, that was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his administrator, his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Ally, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe the evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. Plaintiff, who testified, if you remember, that incident reports are very important. And she testified, and in the incident report, she told her supervisor that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Ally and the building owner, quote, for behaving the way I did. Okay? Why would she apologize to them if she was attacked? Why why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam.
So you can wrap up in about 10 minutes?
Can I have a little bit of extra time since council got extra time?
I don't know that you did, but please try to wrap up.
Okay. I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie. Nicole McKenzie is an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie in April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKenna testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when Dr. McKenzie did the evaluation, plaintiff made no mention of being scratched, cut, or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching. Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her. Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. In response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that were reported, and also that if she saw the patient and saw, if they've got a cut or a scrape or a bruise or whatever, she'd note that as well in the report. And none of that was noted because none of it existed. We also asked plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes in psychiatry. He has impeccable credentials and decades of experience. He, by the way, does not work on a lien basis. He does not work, we paid him, he does not work on a lien basis, so he doesn't have the same incentive that Dr. Mulligan has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in this report, he specifically said no diagnosis. But he did come to conclusions, okay, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms, different symptoms, and so many symptoms that only 2 out of 1 billion people in the world have those symptoms. He also testified that there were inconsistencies with her story. We talked about the McKenzie analysis, in fact, that plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We've talked about the initial incident report, which says a scratch on the nose, but not a scratch on the. So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape. But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff went into Kaiser for a complete history and physical, and plaintiff specifically in questioning denied any kind of mental health issues, including anxiety or sleep problems. In April 2023, she went in again, and for hand pain that time, and she was specifically asked, Dr. Rosenberg said that's what Kaiser does. They ask you about everything, just noted in the records. And she was asked, but again, reported no emotional problems and did not request mental health assistance. I should also mention this claim about PTSD. Dr. Rosenberg testified that you can't, quote unquote, an argument or an unpleasant interpersonal interaction isn't a trauma and can't lead to PTSD. The claim of PTSD is frankly an offense to those people who actually have it. She had a 45-second argument. She was fired. That is not what gives you post-traumatic stress syndrome. And we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulliken is a plastic surgeon. He's not a psychiatrist. So Dr. Mulliken couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories. First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it. And everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified in her February 26, 2018 incident report. Plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was a terrible spitting at her client. Now it's, well, maybe it was an accidental spittle, say it, don't spray it kind of thing from junior high school. There's no evidence that happened, but it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault, and there's no evidence that it even happened. Plaintiff also is strikingly inconsistent regarding her claim that Cardi touched her. We'll go through this quickly. We talked about in the February 26, 2018 incident report. Supposedly Cardi scratched plaintiff's nose. In April of 2018, plaintiff told Dr. McKenzie that Cardi almost touched her. In sworn responses in discovery in this case, plaintiff stated under oath that Cardi viciously beat plaintiff about the head, face, and body. You haven't heard that, in this trial. No one said that occurred. In her deposition, plaintiff stated under oath that Cardi struck her on her nose and cheek, and plaintiff acted out Cardi jabbing plaintiff's face with an outstretched index finger, which is directly contrary to, and you saw that videotape of that, it's directly contrary to what Dr. Mulliken testified he thought happened.
Objection, Your Honor. We're going about over an hour now.
What's your objection?
That we agreed to 1 hour.
Okay, counsel, what's your wrap up?
Can we have 3 minutes?
Just wrap it up.
Okay. I'm sorry, there's more to talk about, but I've got to go. Ultimately, this case comes down to what happened in a minute in a medical building hallway. And to believe plaintiff, you would have to disbelieve Cardi, you would have to disbelieve Ms. Malcolm, you would have to disbelieve Dr. Finke, and you would have to ignore all of plaintiff's contradictory statements, including whether she had a cell phone, whether she had an earpiece, all that stuff. This is not a difficult case. It is not a close case. Plaintiff has the burden of proof, and the evidence is overwhelming in Cardi's favor. Plaintiff has not met her burden of proof. And plaintiff's demand for whether it's the $24 million that was testified to at trial or the $250,000 plus that you heard today makes no sense. She suffered no injury. Cardi did not do anything wrong except try to protect her baby and get to a doctor. The court will provide you with a verdict form, and we urge you that the evidence and common sense require that you answer questions 1 to 2 as no. That will skip you over to section B. We ask that you answer question 5 no. That will skip you over to section C. We ask that you answer question 8 no, which will skip you to section D. We ask that you answer question 12 no, which is then the end of the verdict, and you can have the foreperson sign it. I also want to note that for each of these questions, as the judge previously told you, 9 people do not have to agree. You can have 9 people agree on one, a different group of 9 people on another. And we ultimately, we thank you for your time, for your consideration, and you know how we wish you roll. So thank you.
God damn. He's a good lawyer, but I think after lunch, people started to fall asleep, but he made some good arguments. Let's see what happens now. Wow. Shout out to Petty Pettigrass making it rain in the chat right now. Becky got a membership. Yvette just came in and just got a membership. Dark Snake got one. Desi got one. And Latresta got one. All right, let's go back in and see what's going to happen next. If struggle lawyer is going to come up, but it looks like the judge is keeping them firm on the agreed upon time. Each side got an hour for their closings. Those are now complete. I wonder if he is going to do a time limit for rebuttal. The answer is likely yes, but let's see what happens.
All right, and folks, as we indicated, plaintiff gets the first and last word, so time for a rebuttal case for plaintiff.
Yes, thank you.
Here comes struggle lawyer.
Thank you all for coming back. So this is the end of the road now. I said a lot of things this morning, and I basically don't want to repeat all of it. The main point that I want to highlight, which what counsel has brought up, is the incident report. In the incident report, Ms. Imani Ellis tells her supervisor that the defendant put her fingernail into her face. You will see that. Into her face and scratched her nose. She caused damage to her face. It was a physical contact. As far as the spitting, I never brought up the word spittle. I don't know what that exactly means, but in either event, Imani Ellis, who was there, who was a witness to this incident, testified that the defendant spit on her, actually spit on her, which is an assault and a battery. Everybody gets an attorney. Everyone gets to have an attorney. Even Cardi B gets to have an attorney. All of these comments and all of these things are smoke and mirrors to hide up the truth. Bottom line is, Miss Imani Ellis, who was there, testified multiple times. She never did anything wrong in her life. She was a model citizen, good person, and she basically was doing her job as a security guard. And the defendant refused to cooperate, caused a disturbance, physically assaulted and battered her, spit on her, took a swing at her, and ultimately a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire incident really took place between Imani Ellis and Cardi B, and it really is going to come down to who do you believe? Who do you believe? Are you going to believe Imani Ellis, who was a security guard, who did her job, who was there, who never had any problems of any kind? Or are you going to listen to somebody who's yelling and screaming, has anger management problems,
Objection, Your Honor.
got angry on that day? There's no
Anger
question. She admitted it.
management
She said
problem.
she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word, disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish and try to get a reaction out of her. I don't know how it was that Imani Ellis was able to contain herself, maybe because she is so peaceful. You heard lots and lots of testimony about how she was peaceful. The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this scratch, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you. He said it could be done by either a right-handed person or a left-handed person, either one. And when we had Cardi B on the stand, she said she was disabled because she was pregnant. But at the end of the day, she wasn't disabled with her hands. And you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a bat. In baseball, you must use the correct. No, this could be this injury could happen with the right hand or left hand, and Dr. Melka clarified that and said it could happen with either hand. Again, the evidence that needs to be brought forth needs to be proven by a preponderance of the evidence. We don't have to prove 100%. We have to prove a featherweight more than 50%. In this case, we have given you so much different evidence from different people, which was Imani Ellis, her grandmother, her mother, and all of the medical records. We have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Imani Ellis should receive to make her whole. And
Okay, enough.
counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Imani Ellis was assaulted and battered, and we thank you for your service.
All right, thank you.
God damn.
All right, ladies and gentlemen, that concludes the presentation of evidence and argument. You're now going to be shown to the jury room.
Oh, wow.
We do have a hard stop at 4:30. And by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow. If you want to take a break, you can take a break, but you all need to be back together in the jury room. So please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But for now, can I have Cynthia swear in Vanessa, please?
Yes, Your Honor, the alternate, so we're gonna go to the jury.
Yeah.
Please raise your right hand. Do you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself, nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court? And when they have agreed upon a verdict, you will return them into the court, so help you God?
I do.
And do you solemnly swear that you will take charge of the alternate juror and keep her apart from the jury while they deliberate on the cause until otherwise instructed by the court, so help you God?
I do.
May I please have you state your first and last name for the record?
Vanessa Garcia?
Thank you.
Vanessa?
Yes, ma'am.
I want to talk to the alternate before she speaks to us.
All right, ladies and gentlemen, the jury is officially going to be released for deliberation.
Some personal items, and we're going to go ahead and head into the jury room. Juror number 8 is in the lady. Juror number 7 is in the office. And that alternate, if you could just stay in your seat. Thank you.
right, let's see what happens here. Cardi is probably excited to go home, but we might not be done yet. They might have a verdict today.
And counsel, do you see the door's closed? There it is. Okay. All right, we're still on the record outside the presence of the jury. We do have the alternate number 1 here. Ma'am, on Wednesday, did you have any conversations with any of the witnesses? Were you sitting? Yeah, you.
Me?
Yes. Were you outside? Did you sit next to the plaintiff's grandmother on Wednesday?
The grandmother?
Correct.
I can't remember, but I did sit once, at least once.
Did you have a conversation with her?
I don't remember what I said if I did.
Okay, so she didn't say anything.
I didn't say anything about this.
Nothing about the trial.
No.
Okay, very good.
Not at all.
Vanessa's going to excuse you to the jury room. All right. Thank you, ma'am.
I'll take your notebook.
Thank you.
And then I'll take your.
Thank you.
And just for the party's information, they had some kind of conversation, may have been innocent, I just wanted to rule out an improper contact.
Thank you.
If you could please either stay close or give a cell phone number to Cynthia. Just please stay within a couple minutes in case we get any questions from the jury or if we get a verdict.
Your Honor.
Yes.
So I do want to put something on the record, but not about counsel.
Okay.
I think it's important. I think this court has a duty to handle the situation, which is what happened. During the lunch hour, Cardi B went outside and threw something at one of the news reporters. I have it on video. She's been staring at my clients, all 3 of them, trying to intimidate them. I think it's unfair.
Oh, no.
They feel scared. They feel scared about what she may do to them because of what she did to that court reporter, which I have on video.
Oh, my God.
I'm sorry, to one of the news reporters. She threw an item at the news reporter physically in front of this courthouse on court property outside this courtroom. So I would ask that she be admonished and be told not to handle herself in this way and not to look at my clients anymore.
All right. So the court can't make any orders for conduct that the court didn't witness.
I can show the court the video.
Well, I still haven't witnessed it. To the extent I think it appropriate that the parties be courteous to each other. I don't think it's appropriate for anyone to be either threatening anyone or even by way of staring at someone. People can take offense to that. So please continue that courteously with each other.
Can I just add one thing?
Sure.
I've been sitting here throughout the whole trial. Plaintiff has never looked this way, so I don't know what she's talking about.
Okay.
Second, plaintiff is halfway between Cardi and the jury box and the witness. I have never seen Cardi do anything else other than watch. Sometimes she, in response to a witness, may like wonder like what. But I have not seen anything that plaintiff's counsel has claimed.
Okay. All right. And we do have extra security here just in case there's any kind of issue. All right. Stay close.
Yes, thank you.
Lord, we got a little bit of tea towards the end. So that lunchtime incident, of course, it made it to struggle lawyer because he knows he's losing today. So we are officially, chat, on verdict watch. So that means we are just waiting for the jury to come back with a verdict. I think for me, I am going to continue doing what we need to do for the rest of the day. We have videos for you guys where we can walk through all of the witnesses. That is done. I just need to approve it and post it. And then we're going to do some short form versions as well. But hold on.
Over and over and over again. And all the jury sees is me object.
What just happened? What just happened? What's happening over and over and over again? Yeah, they did, Goddess. They were just the struggle lawyer just brought it up and he told the judge to tell Cardi to stop being discourteous. And for those that are just coming in, I have it. I'll show it to you one more time. I have this video.
Yes, Cardi. What's the verdict? Hey, Cardi, you're beautiful.
Thank you.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me.
I got
How you feeling?
Cardi, your court look is amazing. Who are
You're
you
amazing,
wearing?
Cardi. I still love you, even though you just threw some stuff at
I
me.
don't care. You're disrespectful. Don't do that. Do you see women asking those type of questions to me? Do you see women asking those questions to me?
It's legit.
Why do you feel as a man you got to ask me those type of questions? Act like you have some manners. And your mama taught you, respect women.
All right, Cardi.
Go ahead, Rob. What's up?
Can somebody hand me my marker?
So that is the video in question, and struggle lawyer here just told the judge about it. He also said that Cardi is staring at Imani and her family members in like a rude way. And Cardi's team is like, no, that's not happening. She can't even see Cardi. You know, like she can't even see the plaintiff. The plaintiff's not even looking over here. Imani's not looking over here. So I don't know what he's talking about. Now I'm gonna just hit play one more time because I heard them talking, but they're not showing what's happening. Yeah, it doesn't look like anything's going on. Okay, so what we'll do, we'll be officially on Verdict Watch. My team and I are just gonna chop up all this footage and keep you guys up to date. I'm not leaving this office until it's, 4:30 that they're going to. So I will be here until 7:30. What that means is if a verdict comes in today, I will immediately schedule the live and we will just go live and hear it. All right. And then we'll recap on what the jury decides. If they decide to award damages to Imani Ellis for this 2-inch scratch, whatever, plastic surgery, damages, all of that stuff. Now, they are telling these people to stay close by within minutes. So Cardi B is probably going to leave the courthouse, but typically that once a verdict comes in, or if the jury has questions, which could be possible, this jury might have questions. They had many, many questions throughout the course of the trial. So I anticipate them to possibly have some questions and go from there. But we are officially on Verdict Watch. My guess is that it might come in tomorrow, but they're in the jury room right now. So they have about, what do they have? They have an hour and a half to go for time. So we will see if they come back. The other issue that came up is the grandmother, Imani's grandmother, who was also a witness, was talking to an alternate. The judge just went to that alternate and asked her questions like, hey, what were y'all talking about? Like, were you talking about the case? Because that would be a big problem. So, a lot of stuff going on, lots of tea, chat. Man, oh man, if you want to recap again, I'm about to post it. I have witness by witness everything that we saw on Friday, the opening statements, all the way up to witness number 9, 1 from 9. So you could see that yourself. It's just a condensed 20-minute video that explains the case. So I'll be posting that one. Let me just make sure I got all of our super chats. I think I left off over here with Deshonda. Thank you so much, Deshonda with the 10 says, if Cardi had spit on this lady, she would have used all that security evidence to beat her. I mean, security heavy. She a little plump. I think that's what she wanted to say. She could protect a building. Shout out to Kat Randall Dustman, has been with me for 5 months, says, thank you, AV. No, thank you. I appreciate you guys hanging out with me today. We have been on for just over 4.5 hours. Shout out to Tay Marie with the 2, says she threads it at the ground. She throws it. Okay, so Cardi actually throws the pin at the ground. It was hard to see from that angle of the video that we had from Instagram, but allegedly it was thrown in the direction of the reporter, but at the ground. So yeah, a marker. It might be interesting. Rolla says, AV, have you discussed this at the onset of the case, and how is it that the jury was able to ask questions of the witness? Because the judge allowed it in certain, you'll see this in the video I'm about to post too. I did talk about this. You don't see this in every single courtroom. The jury was allowed to ask questions, but that was because of the judge's permission. I think things work very differently in the state of California, so that might be the reason why you've never seen something like that before. Every jurisdiction handles things differently. California is literally like the Wild Wild West. Like Kim Kardashian was able to take the bar exam without going to law, like without attending law school. You know, like that's how wild they are out there. You know, so Cardi definitely was on something. I mean, I don't think, and I set that poll up, throwing that marker, was it a good look? And we knew, chat, 520 of you have voted, 57% of you say no, it was not okay for her to do that. 30% of you say it was justified. Yeah, because I mean, I think she's right as far as the appropriateness of that question, especially, you know, with everything that's going on with this case. And 13% of you guys say that it was a good look. You know, a lot of people are saying that it did indeed hit the ground. All right, I've caught up on all the super chats. We are on verdict watch, so stay close by, guys. If it becomes after 7:30 my time, after 4:30 their time, then that means they probably don't have a verdict. But if I'm going to keep the feed up, and if we do have a verdict, I will jump back on immediately. So we're on standby. Y'all stay safe out there. I'm going to get back to editing and doing my YouTube thing. All right. But we'll see you in the next one. All right. Huge shout out to our stream sponsor, Zoe Carp. She has sponsored this debauchery. You saw the closing arguments. I'll also chop this up too. So that way, if you guys want to go back to certain parts of this live stream and skip some parts, you'll be able to do that as well. All right, my folks, I'll see you in a little bit. Stay safe out there. See you in the next one. Bye.